In a civil context, you request to admit. Certainly send off subpoenas to other agencies. That's sometimes a good way of discovering withheld evidence. Define the files. Okay, so in a civil context, you want to establish what was the criminal defense file, what was the police file, and what was the prosecutor file. Okay, and that's not always easy to do because sometimes they'll give you just a lump of documents. You have to make sure that they tell you, okay, pages 1 through 1,000, that was the police file. Pages 1,000 and then the defense attorney, you probably have to get to the prosecutor's office or the defense attorney, And then you got to compare all three files, okay, to discover, okay, what's in the police file? Did that make it to the prosecutor file? Did that make it to the defense attorney? So define the files and then compare. What's in the Consider an expert. If you're on a civil case, especially if you can get someone who is a former prosecutor and a former defense attorney about, what evidence, is typically tendered, what's normal, what evidence is material. Using the actual defense attorney sometimes is very helpful. Had I known this evidence, I would have been able to make it to the prosecutor file. So the defense expert's able to say that too, especially if maybe the defense attorney died, or maybe the defense attorney did a terrible job. You may not want that person up there, saying what they would have done with the evidence if they didn't do a good job with the evidence they had. So consider an expert, defense attorney, maybe former prosecutor, in a civil context, and also consider getting the actual defense attorney or attorneys to explain why, A, that they never got certain evidence, and B, why that would have made a difference. In depositions in the civil context, make sure that you establish the chain of custody. Okay, just sort of what I was saying before with defining the files, where did all the evidence go to? Well, think outside the boxes. Okay, what that means is Brady is not always about what's on police reports or in lab reports or pieces of paper. Brady is often about what's not in the boxes, okay? What's not in the police reports. So if you can interview a witness, for example, and the witness tells you something that's helpful to you. Oh, you know what? I really didn't get a good look at the shooter. Okay? But that's nowhere in the police reports. Okay? Well, the first thing you have to say when you interview a witness or depose that witness is say, oh, and when you didn't get a good look at the shooter, you told that to the police officer investigating it, right? Not in the police. Detective Smith, right? Oh, yeah, I told Detective Smith that. Okay? Well, now you just established that Smith knew that and should have put it in his police report. Okay? And then you get the police officer to say, no, had this person told you he didn't get a good look at the shooter, you would have put that in the police report. Right. And then it just becomes a credibility issue of do you believe the witness or do you believe the cop that he told the police officer? And then it just becomes a credibility do you believe the witness or do you believe the cop that he told the police officer? Witness order. What that means is quite often in a civil case, you may not do you believe the witness or do you believe the cop? Witness order in order, because as you take depositions, you're going to find out it might be more Brady material that you knew when you filed the case. Okay? Because ironically enough, our powers to discover things in civil context are much greater than the criminal context. So all this new stuff that comes out during the civil depositions, you can then ask the prosecutors towards the end, oh, you didn't know this, did you? You didn't know this, did you? You weren't given this information, were you? But if you take the prosecutor's step first, you'll be robbed of that opportunity. Okay, so back to our nemesis, Tom Brady. So how do you defeat Tom Brady? Relentless defense. Okay. So that means starting in the criminal case. If you're doing it on the criminal end, when I say first rule of Fight Club, definitely talk about Fight Club. Okay. Prosecutors have affirmative duties to disclose evidence. Okay? So those of you who do criminal defense, you'll probably have been in this position. Judge, I really want the prosecutor to get me, X information. Okay, I'm making a motion for discovery for that information. And the prosecutor will say, oh, we don't have that information. And then the judge will say, counsel, they just said they don't have it. That's not what Brady's about. Okay, Brady's about affirmatively looking for the evidence that you have and affirmatively telling you one way or the other whether they have it. Okay? I cannot tell you how many times I've heard that excuse, and then the prosecutor comes back and magically that's the stuff that you wanted. Okay. But a case called Dennis v. Secretary of Pennsylvania Department of Corrections is called Dennis in the Third Circuit, 2015. Says that in case you need a cite for that. By the way, if you are doing a Brady case, Dennis is probably the best Brady decision I've ever read in my life. It's an en banc decision. It's got multiple concurrences. It also talks about the fallibility of eyewitness identification. It's really an amazing case. Okay? It's a tour de force of Brady. I highly recommend reading that. It's a very long opinion, but it's amazing. Okay. If there is something that you need to find, I'm sure it's in Dennis. Okay. I cite it all the time. Tom Brady. Second rule of Fight Club. So by the way, when I say talk about Fight Club, what it means is don't just have these discussions about your discovery fights, by your, among the prosecutor and yourself. Have it in front of the court. Make a record of it. Okay. And same thing in the civil context. Okay. Make a record of it if you're having disputes about things. Second rule of Fight Club is win. Okay. Heck versus Humphrey. Again, I could do a whole talk on Heck versus Humphrey, but it basically means if you lose the criminal case or not get it overturned.
EA Sports. It's in the game.
15 years before he actually was exonerated, 14 years, whatever it was. Before you do that federal court. Here are my resources. If you wanted to research any Brady issues further, my favorite book is well, not my favorite book, but my favorite book on Brady is called The Brady Book. That is the website right there. It's got a wealth of information. It's mainly quotes from case law, but it's, you'll definitely find something there. This is my article. Is your Federal Circuit woke? It's in the Civil Rights Litigation and Attorney Handbook from 2019. It goes through circuit by circuit, which one requires the defense due diligence rule and which ones don't.
Wonderful speakers today who are all lawyers who are practicing at Tucker Ellis or who had previously practiced at Tucker Ellis. They include Jamie Juvan, Chris Hewitt, Glenn Moracle, and Dan Scheid. They have played a key role in the success of the business law colloquium offered to support upper-level students at Case Western. They have participated in prior years on topics such as corporate governance and Ohio's new LLC law. Today, they are presenting a panel discussion of alternative entity governance and disputes. They will address contractual governance provisions and disputes between minority and majority interest holders. First, a few words about our speakers. There are so many wonderful things I could say, but I will just highlight a few of their incredible accomplishments. So, Chris Hewitt. He began his career in New York at Skaddenar's and came to Tucker Ellis from Jones Day, where he was partner for 10 years. I like this. As a result of that, Chris brings a big law sophistication to each matter while crafting cost-effective solutions with Midwestern practicality. And he's a fitness nut and goes to work out every morning before work. So, Janie Juvan, she's also a partner at Tucker Ellis. She chairs both the Mergers and Acquisitions and Securities and Capital Market Practice Groups at Tucker Ellis, a dual role which seems somewhat extraordinary. She's ranked in Chambers USA in the area of corporate/M&A, Ohio. She is appreciated by her clients for her exceptional M&A knowledge, and clients remark that she's a great relationship builder who always puts the client first. She advises clients on mergers and acquisitions, securities and corporate finance transactions. But what really struck me in reading her biography was that she and her husband Dan are both black belts. So that really struck me. That is amazing. Glenn Moracle, he is now retired from Tucker Ellis, but still coming back to teach Case Western students. He practiced in the areas of business and finance law, primarily focused on buying and selling businesses, to financing the businesses through private venture capital, commercial loans to note and other complex business and commercial transactions and arrangements. He's now retired and has more time to pursue activities like scuba diving, I understand. Dan Shai is at Tucker Ellis, and he is of counsel now. He has significant experience in M&A, finance, and real estate. He wears multiple hats in in allowing him to effectively position and advocate in favor of client objectives. Now, most recently, Dan has been named to the list of 2024 Northeast Ohio Smart Business Dealmakers Rising Stars. The program recognized Dan for his high energy, thoughtful, and thorough approach in transactions. That does not surprise me. He was a former student. His ability to add meaningful value to client engagement and his high level of sophistication and knowledge of M&A matters. It was only a few years ago that Dan was a student in this class, and we are grateful that he is coming back to share his insights with the current class of the Business Law Colloquium. With that, I will turn it over to the panel, who can take it from here.
Thank you, Professor Kuczynski, and thanks everyone for having us. I will say a few of us have done this the past several years, and it's really exciting to come back to Case and see everyone in this room and kind of speak on topics that we live and breathe every day. And so that's kind of when we were planning on the topic for this year. You know, in the past we did a presentation on Ohio's new LLC Act, and we thought, okay, how
Good morning, everyone. Great turnout. Thank you so much for being here. My name is Paul Rose. I'm the Dean of Case Western Reserve University School of Law. It is our pleasure to welcome you to the 8th District Court of Appeals Advanced Appellate Advocacy Seminar. We are delighted to host this seminar again. This is our third year in a row in collaboration with the 8th District Court of Appeals. This annual event is offered at no charge for both in-person and virtual attendees, and it reflects our shared commitment to advancing the art of appellate advocacy. This seminar is a perfect complement to work that we do here in our curriculum at the School of Law. At Case Western, students are immersed in appellate litigation through courses like LEAP 3, which is our sort of third in our research and writing courses, where those students found advocacy skills in preparation for the Dean Dunmore Moot Court competition that we hold each spring. Our students, of course, also represent Case Western on the national stage, competing in prestigious moot court tournaments across the country. I was a transactional attorney in practice, but I was asked to be a moot court coach once upon a time. So this is definitely one of those things where those who can't teach, because I never really was very good at it, but I did have success as a coach, and I really grew to appreciate how much work goes into doing it. So I'm really grateful that our students are doing so well representing us on national stages. The appellate litigation clinic really serves as the capstone of the training that we provide here. It gives students hands-on experience as advocates. In the clinic, our students argue cases in appellate courts throughout Ohio and the Sixth Circuit, including right here in the 8th District Court of Appeals. This semester alone, our clinic has participated in 4 appellate arguments, is managing 12 active appeals, and is awaiting decisions from the Supreme Court of Ohio on whether to accept 3 cases for review. Today's seminar agenda offers a wealth of opportunities to deepen your understanding of appellate advocacy and appellate practice. It begins with insights into effective appellate brief writing and oral advocacy led by experienced practitioners and judges. A panel discussion will follow on navigating through procedural rules and ethics in appellate practice, essential for both new and seasoned advocates. The seminar concludes with a thought-provoking session on emerging issues in appellate law with perspectives from members of the 8th District Bench and Bar. None of this would be possible, of course, without the cooperation and generosity of the 8th District Court of Appeals, the many judges, attorneys, and alumni who support our programs, and of course all of you in this room. Your willingness to volunteer as moot court judges, coaches, mentors has been invaluable in preparing our students to excel as future appellate advocates. And of course, if you'd like to join our community of supporters, you can scan the QR code that's just outside by the coffee or at the registration table to be added to our judges list. So thank you again for joining us today and for your continued partnership. We look forward to a day of engaging discussions and valuable learning. It's now my pleasure to introduce Administrative Judge Kathleen Ann Keogh of the 8th District Court of Appeals.
Good morning, everyone. Thanks for coming. I want to just, on behalf of our court, thank all of you for your participation. It's nice to see some faces that we never get to see, because sometimes in the Court of Appeals, you're kind of cloistered and you don't get to see people. And I want to thank our staff for their hard work and preparation, particularly the Education Committee and all the presenters, and Case Western Reserve for making this possible. We really appreciate it. It's a great seminar. I don't know if it's your first time. It's really fantastic and great participation. And with that, I'd just like to introduce Judge Lynn Jane Boyle, who is the chair of this seminar. Thank you.
Thank you, Judge. Welcome back. 3rd year, and it's growing. I'm excited about this year's program, and I'm just so thankful for the members of my court and the members of Case and the lawyers that have stepped up to participate and present advanced appellate seminar. I think last year I was mentioning to you, I really like to grow the appellate lawyers, community. We seem to me, to be overlooked a lot.
Come on.
We provide this program because a few years ago, well, maybe a decade now, I don't know, they came up, the Ohio State Bar Association in the state of Ohio offers appellate specialization certificates, and you need advanced appellate CLEs. Also, to be on appellate assignment lists to do criminal appellate assignments, you also need a lot of appellate CLEs. And when we heard from the lawyers that there wasn't enough advanced appellate CLEs being given opportunities for you all, our judicial attorneys came to us and said, we need to do this for the community. And so that's why we bring this program to you today. Our first group I'd like to introduce is the program is entitled Missed Persuasive Opportunities. And you're going to hear from Tony Farkas, Dave Parcham, who are staff attorneys at the 8th District Court of Appeals. And then you're going to hear from Melissa Grice, an adjunct professor at Case Law, who used to also work at the 8th District Court of Appeals. So they regularly review the transcripts, the evidence, the records, participate with helping the judges put on decision-making, their opinions, and so they wanted to bring to you what they see from behind the scenes on some of the persuasive opportunities as appellate practitioners that you may be missing. Instead of going through all their bios, you may come on up, you guys. Instead of going through all their bios, you can read it in the electronic format the materials are included in. And we're gonna move rapidly from group to group. So I hope you enjoy this program and you learn lots. With that, Tony, Dave, and Melissa. There's some in the back end. Thank you.
Good morning. I'm Tony Barkis, and as Judge Boyle said, I'm here with Melissa Bryce and Dave Parchin, and we're hoping to provide some suggestions on ways to make the most of your persuasive opportunities in appellate briefs, oral argument, and throughout the appellate process in the Court of Appeals. In preparing for the presentation here today, I sort of the report a little bit and asked for views on what can detract from the effectiveness of an appellate brief or oral argument, or that can just make the appellate process a little more difficult. And so I'm going to try and incorporate some of that feedback here today. In my part of the presentation, I'm going to try and focus on how persuasiveness can be impacted by practical considerations in the way the court operates and the requirements of the appellate local rules. Melissa, professional appellate practice, will provide tips regarding legal writing techniques to maximize the persuasiveness of your written arguments. And then Dave has been with the court for 30 years, and he's probably seen it all. We'll probably do a little bit. We're going to start with appellate briefs. As I'm sure you all know, under the Ohio rules, briefs filed in the Court of Appeals must have 8 components: table of contents, a table of cases, a statement of the assignment of error, a statement of the issue presented for review, a statement of opinion, a statement of facts, and an argument containing an argument and then a conclusion. I'm not going to go through all of that in detail. But one thing I learned fairly quickly when working for the district is that different approaches to reviewing it, particularly with regard to what they review first. Some judges review the assignment of error first. Some review the statement of issues. No way. Some review the order or judgment appeal one, and some review the applied reply. Because you don't know what the judges assigned to your case are going to do, you really want to make the most of each of the elements of the brief. Today we're really going to focus on the heart of the appellate brief. No way. And I'm going to begin with the statement of the assignment today presented for review. What I consider to be the third most important in prior CLE seminars that we've covered here with the 8th District, we've covered what is in my view the first and second most important parts of your appeal. 1, a timely filed notice of appeal, and 2, the record on appeal. If you don't have those two items, or you don't have the need for those 2 items in your appeal, persuasiveness really doesn't matter. So why do I call the assignment of error the third most important part of your appeal? It has to do with Appellate Rule 12A1. Appellate Rule 12A1 tells the Court of Appeals what it must do in an appeal. On an undismissed appeal, the Court of Appeals shall review, affirm, modify, or reverse the judgment or final order of appeal, determine the appeal on its merits, on the assignments of error, the record, and the oral argument at the rate line. And then 3, unless an assignment of error is made moot by a ruling on another assignment of error, decide each assignment of error and give reasons for its decision in writing. So when getting relief from the Court of Appeals, it's really all about the assignments of error. The Court of Appeals is required to decide and issue a written ruling on each assignment of error that's raised in brief. It's not required to address the result of argument or issue raised in. Wow. I'm sorry, some of these are a little small, but I believe you'll get our PowerPoint slides so you can be able to see some of the sites or whatever that's in here that might be a little here. You should be able to get them in a written format. So what's an assignment of error? Common definitions are a concise statement of the question to be reviewed, a short description of a mistake alleged to have been made by the trial court, a assignments of error should designate specific rulings that the appellate challenges on appeal. These are different definitions that have been provided. It's important to note that assignments of error are not proposition of law, like you might see in a memorandum in support of jurisdiction you have Supreme Court. They're not a statement of a rule of law that the party argue should be applied to the facts. They really are a statement identifying a mistake allegedly made by the trial court.
No way.
There are two types of assignments of error. One, general assignments of error, and issue-specific assignments of error.
Nice.
A general assignment of error is a broad statement of a mistake made by the lower court without providing specific details about the error. An issue, something like that might be, for example, a general assignment of error might be the trial court erred in granting the appellee's motion for summary judgment. An issue-specific assignment of error identifies the exact problem with the trial court's decision. Maybe along the same lines, something like the trial court erred in granting appellee's motion for summary judgment because there were genuine issues of material facts with regard to whether appellee reached the contract with the appellant. You really want to make sure and review the local rules. Some local rules have specific rules regarding assignments of error and may require specific assignments of error as opposed to general assignments of error. One thing I've learned is that sometimes there are local rules about things you wouldn't expect to be local rules about. So reviewing the local rules at the beginning of your brief writing process or your appeal process and the end of your brief writing process or oral argument is an important consideration. Here I cited the 3rd District's local rule that says assignments of error to the degree reasonably possible should not be general in terms, but should be specifically applied to the error claim. So just a word of caution. Look at the local rules. Assignments of error really set the parameters of what the Court of Appeals decides on appeal. So how you frame your assignment of error matters. There's a risk of being too specific or not sufficiently comprehensive with your assignment of error. Where an issue raised in an appellate brief exceeds the parameters of an assignment of error, the appellate court may refuse to consider it. For example, I cite this Bradley case. In that case, the assignment of error was that the trial court had waited 37 days to issue findings of fact and conclusions of law after trial. The party in the brief made an argument that it was prejudiced because it was not served with the proposed findings of fact and conclusions of law, and the court said, well, that's outside the scope of your assignment of error. In another case, again, cited here, but it's State versus Zanny, a separation of powers argument was raised as a sub-argument under an assignment of error that involved due process and the confrontation clause. And again, the court said, that was outside the scope of the assignment of error.
Hello?
There's also a risk of being too general or imprecise with your assignment of error.
Like it?
You really have to make sure that your assignment of error identifies the particular action or determination by the trial court that you're claiming was a mistake.
Hey, what's up, buddy? Could you pause the game for me for a second over there? Gotta get my affairs in order over here. Do a line of crack cocaine before we play. Hello?
Resolve assignments of error and not arguments of issues. So if you want to increase the likelihood that the Court of Appeals actually decides a particular issue that you are interested in, you might think
I don't understand what type of alien language you're speaking, you dirty little nigga.
Issue-specific assignments of error are required under the local rules. You can use
I had fire in my eyes.
To really sort of flesh out.
Hey!
We're going to talk a little bit more about that in a few minutes. The bottom line with all this is really think about what you're doing with your assignments of error. I think a lot of times people just sort of, slap them down to comply with the rules, but they can be very, very important in your field. But now I'm going to talk about sort of the technical side of assignments of error. To comply with the appellate rules and be considered by the Court of Appeals, each assignment of error must be raised and argued in the opening brief. You might think that this is sort of, common sense, but you'd be surprised. You can't incorporate by reference arguments made in other briefs that were filed below. It's not uncommon for us to get briefs in which somebody says,
take my hand.
By reference, the arguments I made on page 18 of this opposition, for summary judgment I filed in the trial court. We get that. It's not infrequent. And you can't.
Nobody does it better, baby. Take my breath away. Take my breath away.
Each assignment of error must also be argued separately. Although the Court of Appeals has the option to address 2 or more assignments of error at once, the parties do not. And you can't simply incorporate
Billie Jean on a movie scene. She get the fine ass.
Sometimes we see that in cases where sufficiency and manifest weight of the evidence arguments are made. Sometimes we'll have a party that will say, for the same reasons I asserted that the evidence was insufficient, it was against the manifest weight of the evidence. And really, you need to have separate arguments for sufficiency and for that. Not to mention that they have different standards of review. There might be reasons why we also want to have these different arguments. Assignments of error must also be accompanied by citations for the record, be supported by legal authority, and is supported by contentions and reasons. Arguments be supported by arguments, contentions, and reasons. You have to have a meaningful analysis. Blanket or conclusory statements are insufficient, and the court's not going to make arguments.
I got that dub.
These requirements is grounds that the Court of Appeals to disregard your assignment of error without addressing the merits.
Nice.
And courts do this separately. In the Court of Appeals, if something is not argued separately, if it is not supported by sufficient argument, it's a reason oftentimes courts will disregard the assignment of error. Or they might say, even if we were to consider this assignment of error and go from there. But courts will sometimes, in the interest of justice, consider improperly argued assignments of error. I'm now going to turn it over to Dave, who is going to discuss persuasive opportunities in connection with your statement of the issues presented to review.
A staff attorney with the 8th District Court of Appeals for over 34 years, one of our primary responsibilities is to review the proceedings of the court to ensure their compliance with the rules. Specifically, Appellate Rule 16, which specifies the various components of a brief. One of those components is the statement of issues presented. And generally speaking, all too often, the attorneys and pro se litigants take their assignment of error, turn it into a question, and leave it at that. And the assignment of error is the court erred in granting summary judgment. Granting the motion for summary judgment. And this is done with mind-numbing regularity. In this, you are missing a persuasive opportunity to convince the court. If you can frame this case, the issue presented, the way you think this case should go, you take a big step toward winning your case. Go tonight! Now, there are various ways of doing this. I like the quick punch to the gut. Like, breach of contract case. You say, this case is a case about waiting. Or this case is a case about the statute of limitation. E.g., the guy said, he's agreed to sell me his autographed book, and I gave him the money for it, he never gave it to me. The reply is, this case is about statute of limitations. That transaction happened 16 years ago. It's beyond the statute of limitations. That's how you can frame the case. Now, hopefully, you'll be able to maybe invoke some great principles of justice and law in trying to do this. A good example is the case of State Department against Nunez, the U.S. Supreme Court case. In this case, Marcy Nunez married Mookie, who was a citizen of El Salvador. They wanted to live in the United States. However, the United States law requires foreign nationals to go back.
No way.
Because there was wife, Marcy, starts the appeal, goes up to the U.S. Supreme Court, and Justice Sotomayor said this case is about the right to marriage and the right to live where you want, and thereby invoking the transcendent principle of marriage. Judge Barrett said, no, that's not what this case is about. This case is whether the judiciary has any authority to review visa determinations made by the State Department. That's what this case is about, and she thereby invokes the constitutional principles of separation.
What's that?
There's another way of doing that. See if I can bring it up. But I call this what's often called the syllogism. Now, in certain districts, this is required. I believe it's required in the 3rd district and the 9th district. And in this one, you say you have principle.
What's that?
Oh, no way.
Issues of facts in the case, and then you have your conclusion, a question like a yes or no question stating the issue of the case. And the classic example everybody gives is the premise is the excited utterance exception allows a declarant statement to be admitted if it is made under the stress of the startling event. In this case, the victim calls the 911 shows up 30 minutes later, and Vince tells him, Dr. hit me with a baseball bat. The issue then becomes, is this an excited utterance? So that
Here we go. What's that?
A couple of more cases. That's a case involving burglary. The elements for burglary is trespass into an occupied structure. One of the cases before the court, so that would be your premise. The elements of burglary. The specific minor premise is the testimony of the victim. Vince comes up, I was carrying my groceries into the building, and these 3 guys came out with guns and robbed me. The issue is that sufficient evidence to
No way.
trespass into an occupied structure using the elements of burglary? What about involving burglary? Trespass would be by force. Trespass, you can have consent to enter buildings. That's privilege to enter the occupied structure, but that can be legal, and it can be terminated by a violent act.
Think your taxes are simple? You can file for free with H&R Block. More people qualify for H&R Block free online than TurboTax.
Welcome to the Regulatory Transparency Project's 4th Branch podcast series. All expressions of opinion are those of the speaker. Hi, and welcome to the Regulatory Transparency Project's 4th Branch podcast. My name is Steve Schaefer, and I'm the director of the Federal Society's Regulatory Transparency Project. We are pleased to have with us today 2 stellar experts. Note, the opinions expressed are those of the experts and not the Federal Society. First, we are happy to have with us Randall Johnson, distinguished immigration scholar at Cornell Law School. He has worked on employment and immigration law and policy for over 25 years, bringing a broad perspective from working in executive agencies, working on Capitol Hill, as well as in the private sector. We're also happy to have with us Andrew Kilberg, partner at Gibson Dunn. He is a partner in the Washington, D.C. office, where he practices in the firm's litigation department. He has significant experience challenging regulations, advising on regulatory proposals, and defending agency enforcement actions and investigations. And both gentlemen speak in their personal capacity and not for their respective employers.
Well, thanks so much for that introduction. And this is Andrew Kilberg speaking, by the way. Randy, you've had 20 years in your career, over 20 years at the Chamber of Commerce. I think about a decade on the Hill or more. A couple different stints at the Department of Labor, plus not insignificant amount of time at a major international law firm focusing labor issues. Here we're hoping to talk about immigration enforcement, particularly with respect to small businesses. And I think this is really a very timely topic with the new incoming administration obviously having understandably a huge focus on immigration, not just on border issues, I think, here, but also as it impacts employment policy more broadly. So I was just hoping, in light of to start with your extensive experience in this area. I know you've been writing a lot about this too. Can you give a brief overview of what's driven you to look at this topic, particularly how this might be reformed?
Well, thanks, Andrew. And I'd like to say I'm not the guy who can't keep a job. I'm more of a Renaissance man, so just for the record. But I just spent a lot of time on the Hill and at the Chamber, and frankly, my life was focused mostly on legislation on Capitol Hill, trying to pass a few pieces of good legislation, mostly trying to kill bad ones. And also laying the groundwork often for oversight on regulatory issues. For example, I was very much involved in ergonomics on Capitol Hill, and in fact, I ultimately, when I went down to the U.S. Chamber, co-chaired the National Coalition of Ergonomics, which used the Congressional Review Act to overturn a regulation, which was the Clinton-era ergonomics reg. So my life was focused on legislative and regulatory issues. But we did have oversight hearings, and we did have small businesses come up from time to time, whether it was NLRA or OSHA or EEOC. That was probably the big three. And Andrew, is when you're a staffer, relatively young, and you're sort of listening to people trying to run a business, and frankly, the government's gone in with much violation, and these businesses are getting crushed by the government, not because of the allegations per se. I'm not saying there aren't any bad actors, but in this case, they just didn't have the resources to fight back. And then you see that how that it was a personal affront to them in terms of how they related to a government which they normally thought would have treated them fairly. And then they didn't have the access to use our vaunted judicial review system here, which is a fundamental aspect of the rule of law, because they didn't have the resources for it, and they couldn't put up the delay. They couldn't put up with the delays that it took to get something, a resolution to the system. So they gave up. And we had hearings on that, and I just said, this is not right. And then when I went down to the Chamber, we had a lot of big companies that are members, but we had a lot of small employers, and I would hear these sort of same stories anecdotally. And I just thought, this isn't America, frankly. And I know the old thing, but you can't beat City Hall. But we should be able to do something about this, which is these smaller businesses simply don't have the resources to defend themselves. Eventually I looked at it, we have something on the books called the Equal Access to Justice Act, and it's called Equal Access to Justice Act for a good reason, which is it was meant to help small entities take on government when they were innocent, and if they won their case, then ostensibly they were entitled to get their attorney's fees. But I think, as we'll talk about later, there's problems with how that act actually rolls out and the ability of employers and small entities, by the way. It's not just employers. The Equal Access to Justice Act was intended to help small individuals, small employers, small nonprofits. And so we had a lot of hearings on the Equal Access to Justice Act. And I used that knowledge when I went up to Cornell to work on immigration, and my portfolio was immigration, so I used that to write a paper on immigration and interview businesses and actual practitioners on how I-9 laws were enforced and the problems employers again had in defending themselves against government overreach.
So, you can correct me because if I'm wrong, it's not my primary practice area in terms of immigration. But most new people who applied to a job, got a new job, understand you fill out a form at the beginning and it says,
this is who I am, or you hand over your passport or driver's license, whatever it might be, to prove that you are who you say you are. And my basic understanding then is that the employer has to complete the I-9 form, which is a way of verifying that the individual is not only legally in the country, but importantly, legally authorized to work in the country, not a tourist or some other person who's passing through here doesn't have authorization to work. So, you know, I just wondering, can you tell me, correct any errors, but also who enforces this, and what are the pitfalls of that?
Yeah, and of course, before 1986, you could work illegally for an employer, and then under Ronald Reagan, they changed the law, and for the first time, it was illegal for an unauthorized worker to work for an employer. It's illegal for the worker. It's also illegal for the employer to hire the worker. You enforce that through what is called the I-9 form, which you talked about, which is 4 pages. And if you look at it, you're like, oh, this doesn't look that hard. There's the manual that explains the I-9 system. I looked at it last night. It's over 130 pages. The regulations are about 10 pages. There's multiple documents that.
In 1984, the Air Jordan was banned from the game. Nike could have paid a fine, but they didn't.
Why should we pay $5,000 for a pair of sneakers?
Because there'd been...
A worker can offer to the employer to show they're authorized. It's not passports is one, but and it's an ever-changing sort of list of authorizations. And then the form itself has multiple traps for employers to make mistakes on. But yes, that's the bottom line. Is you fill out the I-9 form. That shows that the employee is authorized to work. And hopefully the documents weren't fraudulent. They were reasonable on their face. The employer must accept the documents if they're reasonable on its face. And the employer may ask for additional documents or ask too many questions of the applicant, because then they might be accused of discrimination based on national origin, which the law also provides back in 1986, a provision of non-discrimination, principally to protect Latinos. But that's enforced by the Department of Justice. So if you're an employer who asks for a document that's not on this very complex list, you could be dragged into court or by the Department of Justice, because there is a private cause of action, by the way, on this also. And so, you know, it's not as simple as it appears, like, oh, let's just fill out a simple I-9 form. But yes, that's the basic process. Validate that the person's authorized to work, but it's become a whole cottage industry now.
Mm-hmm. So, you know, if I'm an employer and John Smith shows up at my doorstep, wants a job, I've got an ad wanted out, you know, presents to me documents, they appear real, maybe I have access to E-Verify, I run them through, run the social security number, it's there. I'm not allowed to do anything else as long as I fill out the form. But, you know, because if I do, I might be subject to either a lawsuit from the Justice Department or from John Smith asserting that I violated his civil rights. But if I don't do anymore, I might get a knock on the door from ICE saying, we know John Smith is illegal, and now we're going to investigate you for hiring an illegal immigrant.
Right. Yeah, and on E-Verify, just the I-9 documentation is separate from E-Verify, and most employers don't use E-Verify. A lot of them do, but they're sort of separate, but the same type of issues. And Andrew, I have to note that it's no secret that there's going to be a ramp up of enforcement checks against employers under the new administration. I'm picking up this from a lot of practitioners who are certainly going to have a lot of billable hours in the future advising their clients on how to prepare their I-9s.
We're good.
But it's interesting. I was thinking that if you're an employer and you're like, oh my God, I'm going to be hit by a lot of major I-9 audits, and you start going back and looking at your books, if you look at them too carefully, again, you might run up against this catch-22 of like, oh, you're just going after Latinos now. You're just checking people who look Latino on your books instead of all the other. So employers have to be very, very careful on this, or they can be trapped either way.
Yeah, you know, and look, you know, this one could say, well, there's some leeway on enforcement from DOJ, but as you pointed out, there's a private cause of action, and you know, we might all hope that the next administration stays in office for a long time, but elections are elections, and sometimes they go the other way, and statutes of limitations the way they are, there's always some risk.
down the road that you get hit with a lawsuit from DOJ where control has been turned over.
Well, it's just you may have statute of limitations because it's just a little niche, but there's a 5-year statute of limitations under both I-9 lawsuits for ICE, but also for the private cause of action and the non-discrimination area. I have no idea what it's 5 years, but I can tell you as a labor lawyer, as you know, Andrew, that's a very long time. Usually it's 2 to 3 years, 3 years if it's willful. Yeah, and so it's there are a lot, but it's a world in which you could say you follow everything, but I guess my concern was what I heard from many employers was they really did do the best job they possibly could, and they thought they were in compliance, but there's so much discretion that enforcement officers have, and many times employers were threatened with debarment or criminal penalties over some XYZ technical violation, and the employer's like, I didn't really do anything that bad, and the compliance officer is, well, maybe you did, maybe you didn't, but you don't really want to be debarred, do you? So let's just settle this at X level. And as you know, debarment is the capital punishment for many employers. That's their lifeblood. And so they're forced into settlements, and many people would say, oh, that can't happen, Randy. They just go to court and appeal your rights and show the compliance officer was wrong. These employers can't take the time, and they don't have the money to go up the chain, which goes through an administrative law judge, justice, goes up to the district court, then the court of appeals, and then you might get a resolution.
Yeah, and so in debarment, of course, being for federal contractors, and that, often we think of the gigantic companies as federal contractors, but really is anyone who might be supplying groceries or cleaning services or whatever to, say, a military base somewhere in Kansas or wherever. There's thousands of businesses that are federal contractors, large and small. You mentioned...
At Harvard Extension School, there's more to the student experience than you think, like access to our expert faculty.
You mentioned both the investigation and then, the ALJ process. The ALJs that's within DHS?
No, those are at Justice.
Okay.
Yeah, it's got a complicated name. It's the Office of blah, blah, but it's basically immigration courts in Justice.
But most cases, it seems like, I'm not sure if there's clear statistics on this, but it sounds like most cases probably don't ever get to an ALJ.
Well, this is an interesting area of what really happens is I call it the base of the pyramid in enforcement. People track legislation. You can track regulation through the Federal Register. What really happens at what I call the base of the pyramid of American laws, which is enforcement, has always been unclear because no one tracks that. It's very hard because everything is there's multiple cases, but each case is very individual. And so no one really tracks what goes on in those individual cases, much less how many. So the answer is, I'm sure you are right, because obviously we all know cases settle because people can't afford to go to court. That's why they settle. And it's interesting, even when we did the 1991 Civil Rights Act on Capitol Hill and tried to draw analogies to what was happening in California, we had to bring in practitioners to talk about what really happened at the ground level, because you can't look at this in a book and figure out what really happens when these laws are administered. And so when I did my paper, I didn't just look at the case law. I also interviewed practitioners and put that in the paper to get a grasp of what's really happening out there. Is that somewhat anecdotal? Yeah, it is. I can't talk to 1,000 practitioners.
No way.
But I think it's consistent with my years of experience of 30 years of talking to multiple people and hearings on Capitol Hill.
From my experience as a former Department of Labor official and in private practice, so many of enforcement actions never actually get to the action part of what, the lawyers or law students listening think of as going to court, or whether that's a Article 3 court, Article 1 court, or something less than some kind of administrative hearing. Most enforcement happens through investigation, and if there is a finding, through some kind of resolution with the agency, whether that's a settlement or an informal agreement with the Wage and Hour Division, whether that's a settlement, over an I-9 violation. It just seems to me, if you could speak a little bit more, you talked about it before, the kind of expense and time that goes into these types of small business immigration investigations. at the investigation stage, way before it ever gets to an ALJ.
Well, let me say when I talked to lawyers, it would be to take something up through the ALJ level. The estimates I got were 80 to 100,000, and then of course the Ninth Circuit was of course more. You know what happened below that? Again, there's a famous case called Fisher Holmes. It was written up in a book, by the way, and where well, frankly, under the Bush administration, Chertoff came in and raided this company, and that company was in 3 years of hell with the government just poking around, trying to find something. There was a lot of things going on Capitol Hill at the time, frankly, which was comprehensive immigration reform. And one of the theories was the government was actually trying to get employers to be more active on the Hill, and so they went after them in enforcement. I can't prove that, but I can tell you it was likely true. So having been involved in that. And that company, as documented in the book, hundreds of thousands of dollars just that guy could afford it. And he makes the point that the CEO of the company is interviewed in the book says, I could afford it, but I tell you, my supervisors who the government went after in alleging criminal allegations could not have done it had I not been able to back them up. If they had been a small employer or just an individual hung out to dry, they would be in jail. And so it's a lot of money. I can just put it that way without trying to quantify it. And what happens on the enforcement level before they go to court, again, this goes into, Andrew, a company knows it's going to be a laborious process. So they're like, screw it, let me just get out, let me settle, let me get this guy off my back and let him go over to the next guy. Right. And that's what we heard from, hearings on Capitol Hill and interviewing with practitioners. And that's not right. And that's why I went down this road of exploring why the Equal Access to Justice Act wasn't effective in helping these small employers.
Just before we get there, I think you mentioned before just how the I-9 form, it's short, but there's pitfalls in it. And if I understand correctly, there are violations for making errors on the forms too. This is not just where it's been investigated and determined that the worker in question actually was unauthorized to work. That there can be a violation simply because the form wasn't filled out properly.
Well, completely, or you didn't file it in the right place, or you didn't meet the 3-day limit. You didn't have the right type of receipt. And I looked at the regs again last night, and there's 4 pages of regs of sort of violations that aren't related to whether or not the worker is in fact unauthorized. But here's what one practitioner, who's actually a former Department of Justice guy, but let me just read this. To illustrate the impact of this enforcement philosophy, an employer may have a Form I-9 for all 2,000 employees, but somehow make clerical errors on half of the forms. These errors can be as innocent as failing to check a box or fill in a blank. The penalty for paperwork mistakes in this scenario can be as high as $2,000 per employee or per Form I-9. Therefore, even if all 2,000 employees are authorized to work in the U.S., this not-so-large company with a workforce of 2,000 can be liable for a $2 million fine just for not filling out the forms perfectly. And so this is a long-time practitioner out in the field, and I'm not making this stuff up. Again, that comes back to the form itself is 4 pages. The manual that explains it is 133 pages, and the regulations themselves are, just that section are probably 10 pages in the Code of Federal Regulations, which are fine print and very complicated.
Three columns when you talk about a page. What you're saying is it makes a lot of sense. You see discussion of this periodically in various agencies and in various circumstances about the ability to stack penalties. So you might just have one basic error. Say you have a HR director, small to mid-sized business, one person always does the I-9s. They do it wrong every time in one little aspect. But if they do it wrong every time, in private practice or businesses, we think, oh, I'm making one error, but it's multiplied, and that's where your penalty is picked up. And that's where it's a leverage point for the government comes in and says, you did this 2,000 times. Say, well, no, I did it once. And they say, no, 2,000 times whatever, that's a lot of money. And that's a way of bringing businesses to the table for resolution when they say, I can't pay that.
Yeah, and I've seen this in other ways where a company hired an HR
No,
they brought outside experts, but there's
Planning to move? Join
Hey,
the
let's go.
6 million families who discovered a smarter, more flexible way to move with
error on one form, but then it was multiplied by every employee, which in the regs is per employee or per person.
No,
So, you're like, okay, in that case, well, in that case, that is what the reg says. And so it's not that the compliance officer in that case is going out beyond the regulations, which I would argue often happens also. But you got to just pay up. Again, and I think you combine now with these situations of as I've heard from practitioners in the case law is compliance officers trying to push novel legal theories or trying to use debarment or the threat of criminal penalties to leverage settlements. An employer can't hire a Gibson Dunn. Let's face it, well, some can. Most can. But many can. And they're like, okay, just let me, what do you need? Let me just get out, let me write a check. And the compliance officer then moves on.
Yeah, and so I want to get into the Equal Access to Justice Act. I know you're eager to discuss it. It's an important topic. To kind of roll into that, it seems to me what we're really ultimately when it comes down to talking about is how do we balance the right incentives and disincentives. So we said at the beginning, I think everyone around this table recognizes that there's a big immigration problem, and that something needs to be done. The question is exactly how to approach it. And there's a lot of employers, a lot of small employers and big, who want to do the right thing and are trying to do the right thing. In the government, there's a lot of very good agents out there and supervisors who are just trying to do their job to the best they can with really high workloads, lots of cases trying to get through them. How does the Equal Access to Justice Act kind of work within those incentives? And I might interrupt, but the follow-up is how could it be tweaked by Congress to better balance those incentives?
Yeah, and you reach a couple of good points in there. First of all, for I think for the listeners, because I've been how should I say, disturbed. How many people I talked to have never heard of the Equal Access to Justice Act, which in fact tells you something about the fact it's not as used as perhaps as Congress intended. It was passed around in 1984, and it was intended as a way to help level the playing field between small entities and individuals and the government. And let me just one of the broadest and widest reaching federal statutes on the books to ensure that certain parties, particularly individuals and small businesses, are not coerced into complying with government actions simply because the litigation expenses involved. It's meant to discourage the federal government from using its superior litigation resources unreasonably. It is in this respect an anti-bullying law. Close quotes. That's out of a recent committee report. This is out of the Ninth Circuit. Enacting the EJA, Congress stated for many citizens, the cost of securing vindication of their rights and the inability to recover attorney's fees preclude resort to the adjudicatory process. Which most Americans think they have. When the cost of contesting a government order, for example, exceeds the amount at stake, a party has no realistic choice and no effective remedy. In these cases, it is more practical to endure an injustice than to contest it. This is America. And this is the Ninth Circuit. In these cases, it is more practical to endure an injustice than to contest it. Why is that? That's because the much vaunted rule of law, which allows people to contest when they're abused by the government as citizens to use the judicial process, is more ephemeral than real because they can't afford it because of the cost and the delays. So the purpose of EJA was to try and address this. And it said that if you won your case against the government, again, an individual or a small business, you are entitled to your attorney's fees and costs in litigation, Andrew, unfortunately not in the investigative stage. So there's a limit. But it allows the government to still get off the hook if the government can show that its case was quote unquote substantially justified. And there's another called special circumstances, but substantially justified. So the government loses And then the employer says, oh, I'm talking about attorney's fees. They're like, oh, no, we're substantially justified, even if we lost. So now the employer has to relitigate the case to show that the government was not substantially justified, which shows that the government normally routinely opposes because they don't want to admit they made a mistake, and for a lot of reasons, and they probably don't want to tell their boss they lost and have to pay the attorney's fees. And so again, I've heard from employers that say, we're not going to relitigate the case twice, we're just going to get out. And so one proposal is to eliminate that loophole of substantial justification. But to your other sort of point, I think here is, well, what's that do to the sort of broader enforcement regime? Well, I would argue it provides a good deterrent for the agencies to say, you know, under this new EJA amendment, we're exposed to attorney's fees if we lose. So let's slow down here and take a look at this case we're bringing against this small business or entity, and make sure we've got a good case before we bring the awesome power of government against this ex-employer. And I'm not saying your big clients, Andrew, wouldn't like to say that to happen. I'm saying no. There's a special case to be made for small businesses that government, I think, I spent 3 tours at the Department of Labor, should slow down and take a special look at should we bring the power of government against this person, and I think that would help target resources among the agencies to against more important cases. So it's not just about helping the employer, it's helping the government better target its resources, which, as you know, haven't been a deal well also. Agencies always complain about and then when I look at these cases that go up to the 11th or 5th Circuit with these crazy legal theories, I say, if they don't have any, if they're limited resources, why are they bringing these crazy cases? I mean, it's sort of counterintuitive, but I think these kind of changes under EJA would help sort of better, frankly, target enforcement resources along with helping small employers.
And do you think there'd be any, under your theory, would there be any trickle down to the investigation stage, or would this just prevent them from actually filing the action if the small business doesn't settle?
Well, I think the trickle, well, first of all, to get down to investigative stage, you'd have to amend the statute in another way, plus, but I think it would trickle down in this way. I think the business or entity could say, well,
no time. Granger has over 1,700 box types in stock, and ready to help you pack, store, and ship everything. And you can count on Granger to deliver your boxes fast. Count on Granger for boxes. Call or click Granger.com/boxes.
This is crazy what they're doing investigating me, but I've heard about this new EJA, Equal Access to Justice Act bill is amended. So I'm going to fight these guys, and I'm not going to settle, and I'm going to move up through the system. I'm still taking a chance I'm going to win. But if I win, and I feel I'm going to win because I'm innocent, at least I've got a shot now of reimbursing my costs. So I think it'd be a trickle down, but not sort of, you know, a direct effect. You know, I just want to real quickly, because I know I'm talking about employers, but there was a great case in the 9th Circuit that a woman was on the no-fly zone, and she had to fight for 5 years to get off that no-fly zone. And it turned out she was on it only because a guy buried in DHS literally checked the wrong box on a form. And she had to fight that. Well, she had discovery to get it, and she had a law firm. And then the government fought the attorney's fees, even after they admitted it was a clerical error. And the 9th Circuit went to the 9th Circuit like at least twice, maybe 3 times. And the 9th Circuit finally said the government is engaged in scorched earth litigation.
Alert!
And we're giving attorney's fees to this law firm. My point is, it took 5 years, and it had not been for EJA, she would have been, you know, out of luck, as many small entities would have been.
One issue that probably wouldn't be solved, at least directly, by a legislative reform that you mentioned is talking to people in the middle. Lawyers may have, but if someone's sitting out there thinking, oh, gosh, this is going to be expensive, what do I do? They don't even know that there's an opportunity to maybe get a lawyer and not have to pay in the end. How do we solve that? Just your time at the chamber, the public education aspect of this than I do.
Yeah, well, I can tell you the plaintiff's bar is darn good about getting word out about new statutes and private causes of action. So if we were able to get these kinds of reforms done, I think groups like the Chamber, and particularly and NFIB in particular, because it represents small entities, would get the word out pretty quickly. And I think we would see a turnaround. Now, there is a cap on attorney's fees of $125 under EJA. That's something that
$125 per hour.
$125 per hour. And I think you probably bill a little higher. And that would be also something that I would like to, if possible, if we ever got this legislation moving. Unfortunately, lawyers are not the most popular people on Capitol Hill, so they're not the first victims you want to lead with in trying to achieve corrections.
Well, I mean, honestly, lawyers are probably the most popular in Washington, D.C. of any jurisdiction in the country. But that's neither here nor there. You know, we were talking about this the other day, you and I, Randy, about, I think that another potential issue with EJA is who pays the fees if there is a successful EJA action. And my understanding from you is that it comes out of now for the immigration area, that actually might work fine. DOJ's, doing the cases, or they're in front of the DOJ, ALJ. But for other agencies that are kind of zoom out a bit, maybe outside the immigration context, is there a mismatch in the incentive? If I'm a DOL or I don't know, an HHS, if they have some kind of an enforcement action, regardless of the agency, letters, they might say, well, yeah, that's not skin off my back. It's not my appropriations. Let the DOJ guys deal with that with Congress next session.
Yeah, no, it's another wrinkle. It kind of cuts both ways because when I was up on the Hill, there was a bill that amended the National Labor Relations Act that provided the fix I was talking about, eliminating substantial justification, passed the House by one vote. But people were criticizing it because it would hurt the NLRB's ability to bring cases because they would have less money. Well, because we come out of the Justice Department fund. So in some ways, it undermines that argument about hurting enforcement. But to your point, yes, arguably less deterrent since it's not coming out of the agency's budget. But I would argue it still would be a not proud mark for the agency to have to be responsible for a lot of people. And therefore, I would hope would still be a deterrent to the agency to bring these kind of cases. Would I prefer to come out of the agency's budget? I would. Having walked the halls of the Department of Labor, I think there's some excess money there to be used for these kinds of funds. But yeah, that is a sort of a sidebar agency. You can see how I can argue both sides of it.
Yeah. Well, and I lost my train of thought. I had an excellent point that I was going to pop that, but I have missed it. One other thing you and I talked about, though, is also the statute of limitations. And I mentioned this before, but the government can sometimes take kind of aggressive positions on that. And how does that kind of roll into this, too?
So which one now? The
statute of limitations.
Oh, statute of limitations, yeah, the 5 years. Well, well, there's two parts to that. One, because ironically, I've seen it reported by attorneys out in the field. Hey, let's go. Sometimes the compliance officers don't even know the proper statute of limitations. But when they do, they can use it as a weapon to say, look, we can go back 5 years on you. And I'm not even getting into continuing violations and all that there. We can go back 5 years of improperly I-9 forms. Why it's 5 years?
Starting a new job or leaving an old one? Your life changes, your taxes do too. With 70 years of experience.
I'm not sure. Maybe it would be, actually with the recent Supreme Court decision on posts or whatever it is, maybe it's more. But it's, again, I think that's an example of given the fact it's a 5-year look back, and I've seen, or as I discuss in my paper, situations of where compliance officers have not been fair. I think the 5-year statute of limitations exacerbates the concern about compliance officers having this kind of discretion to pressure employers into settlements by threats of debarment or criminal penalties, combined with the inability of the employer and the court to vindicate their rights. I think it's almost like rubbing salt into the wounds.
And, you know, I was just thinking through kind of other, setting aside EJA, other types of reforms that maybe sometimes agencies themselves could impose to their processes, be kind of procedural rules that could fall within their authorities to just manage their own enforcement programs. You know, you and I talked about the other day one possibility of kind of mediation programs, an ombudsman that it would be ostensibly as neutral as an agency body could be. That's there for the sole purpose of trying to bring the agency and the business or the individual together to a resolution that's actually fair. Is that something that, you know, we've seen this, we saw it, I think it was relatively successful at the Office of Federal Contract Compliance Programs under Craig Lean in the last administration, in the first Trump administration. Is that something that ever could work in the immigration space with respect to, you know, enforcement on businesses?
Yeah, in an ideal world, and I've tried this one successfully, I would hope an agency head, whether pick your choice, would actually voluntarily say, hey, I read this great paper by that Randy Johnson guy. Let's voluntarily get rid of this substantial loophole, and we'll pay the attorney's fees to small businesses. Did not get traction on that. But to your point, yeah, and if I was Secretary of Labor, head of DHS, particularly if I wasn't going to be called up for oversight hearings, I think a memorandum that says, look, we're not changing the law here. This isn't an APA issue, but let's just be conscious of the fact of how much power we have, and that small entities and small employers don't have the resources to fight back. So let's just be more careful. And to your point, let's if you're going to bring a case, let's assign a mediator to it.
Another example, again from OFCCP in the Trump administration, was self-limiting by evidentiary standards. And so this goes to your point, you know, that's a different context. It's about, you know, a slightly different context in terms of race or sex-based discrimination or discrimination based on veteran status among federal contractors. Basically, the whole universe of private employers with who meet the statutory thresholds. But there I was saying, no, we have to make sure we have enough evidence before we go to a case. Give the evidence, you know, the basis for our allegations to the business in advance to try to promote resolution. It seems like there are lots of reforms that agencies could do, and with EJIS particularly to latch onto it, you know, what do we think substantial justification is? And let's make sure that we're meeting that before we walk into the ALJ, before we walk into federal court, wherever it may be.
Yeah, before we start the initiation instead of on the after all that. Yeah.
Sometime in the investigation stage, you check-ins, and you make sure that it's justifiable to spend the limited agency resources to continue it.
Yeah, and EJA was a congressional determination that small entities are different than large entities, and they deserve a little. So the agency is not making this up. It's really a congressional sort of theory that's embodied in EJA. In fact, you know, will probably not be the next chair of the Education Workforce Committee, but she has asked for to look at this entire area. Because I'm not saying, you know, there might be other reasons why there's so few EJ cases filed, as demonstrated by the Administrative Conference. But she's asked for a GAO to look into this entire area. And so it's not just this issue I'm looking at. I'm glad to see that the Congress is again, and maybe we'll get some traction out of that with the Republicans having kept the House and taken over the Senate.
Well, I think at least you and I agree that we'll miss Chairwoman Fox as the chair of that committee. Such an advocate for fair and balanced enforcement and really clarity and guidance to employers and employees both in terms of what the law is, not just what it should be. And she's been an excellent congressperson. I remember the point I was going to make, and this is the last thing I want to say before I think, you know, ask you if there's any last words you want to give on this episode. Is that Inspector Generals, it's a baseball really DC thing, and people who, if you're listening not in DC, you might not ever really think about them. But to people in the agencies, they matter.
Easy, 63, 63,
and they have
bang!
pretty decent authorities and power to look into what's going on with the agencies.
No way.
Stories. Usually it's more about like a DOJ inspector general, something sexier like that. But they have them for if not all, most agencies, at least the departments. And that's, it seems that could be another way of looking at, particularly if there is EJ reform, even without it, how are we, are there issues here with bringing cases that end up not being substantially justified?
Yeah, I guess that's a good point. IG's...
Say goodbye to Slack because chat's here and it's inside ClickUp. Everything you need in chat is here. Like your DMs and even your channels. But there's a ton more you can do. Chat conversations can lead to so many new ideas. And now you can turn those ideas into action.
I don't think I ever wanted that job when I was at Farm Labor, but they're on a interesting string, and their authority is, despite I would say somewhat unclear. But I think that's a good point. That's something that, but it would have to come back. The directive would. No, I guess they could independently decide this is an area to look at. It wouldn't have to come down from the Secretary of Labor or whoever, and their efforts could certainly help supplement perhaps the GAO's study.
Yeah, something to think about. I mean, it's not. They're not going to drive specific changes. They're not going to be out there educating people about EJA and changing that system fundamentally. But just a thought about how this, in practical terms, might proceed if they're absent congressional action. So, I don't know, Randy, is there anything that I didn't ask you or didn't hit on that you wanted to?
Well, I think I just there on these two words, substantial justification. Yes, there've been Supreme Court cases on it. That doesn't mean it's clear what it means, because there's a great ILR piece out there that goes through a litany of hundreds of cases. If there's hundreds of cases, that doesn't mean it's clear. It means it continues to be litigated, and that gives you an idea of the kind of headwind that an employer would have to show that their case was, that the government's case and when they won was not substantially justified. And secondly, and it's a great read, I find it interesting, the United States recently started up again reviewing the use of EJA awards under the agencies, and there's 4 years of reports out now. They were actually defunded for a while. Now they're back. I'm glad they are. That's a whole other story. But and the numbers of EJA awards are just minuscule when compared to the portfolio of these agencies. So it's DHS, Department of Labor, EEOC, NLRB.
No, touch that!
Most of these awards that were made were made by now, I'm talking about a small number of like 4 or 10, so it ain't a lot to begin with. But the point is that tells you the agencies, even those small numbers, fought them all the way to the courts, because the courts had to step in and give the award, rather than the agency saying, "Oh, we messed up, let's give the award."
No, touch that!
I'm just it's a little insight into how these agencies fight these sorts of awards, even if they lose. But the numbers again are minuscule, which I guess I'm a little biased. Based on what I've seen from many enforcement agencies. That's not because all these cases are non-contestable.
No, touch it!
It's because the numbers are so small.
It's going to be very interesting to watch how this all shakes out. As I said, I think everyone expects that there's going to be a lot of movement, in the immigration enforcement space. We often, consumers of mass media, think about individuals crossing the border, but there's a lot of, there's going to be probably a lot of attention on the business side too, and it's going to be interesting to see how it all shakes out.
Yeah, it's going to be interesting 4 years, and so Gibson Dunn may want to get into the immigration I-9 enforcement space, but
I can't speak to that. Again, I'll just remind everyone that all opinions expressed were mine and not the law firms.
And mine are not Cornell's.
I want to thank you, Randall, as well as you, Andrew, for this insightful conversation. It's very important. And thank the audience for tuning in for more content like this that involves the regulatory state and its impact on the American way of life. Please check out regproject.org. That's regproject.org. Thank you.
Dubs.
Federal Society's regulatory Transparency Project, thanks for tuning in to the Fourth Branch Podcast. To catch every new episode when it's released, you can subscribe on Apple Podcasts, Google Play, and Spreaker. For the latest from RTP, please visit our website at regproject.org. That's regproject.org.
This has been a FedSoc audio production.
Welcome to the Regulatory Transparency Project's Fourth Branch podcast series. All expressions of opinion are those of the speaker.
Hello, and welcome to the Federalist Society's Regulatory Transparency Project's Fourth Branch podcast. Today, we will be discussing the pros and cons to age verification in regards to online privacy and children's safety. My name is Elizabeth Dickinson, and I am an Assistant Director with the Regulatory Transparency Project. As a reminder, all opinions expressed are those of the speakers and not of the Federalist Society. Our moderator today is Jennifer Huddleston, Senior Fellow of Technology Policy at the Cato Institute. Jennifer, thank you so much for joining us today.
Thank you for having me today, and I'm very excited to talk about this particular issue, an issue that raises a lot of questions and illustrates a lot of the tensions that can occur in different rights and different policy approaches. For example, many people are concerned about what young people may encounter online, but there remains a question of, is there any sort of government role in assisting parents in making those decisions? At the same time, laws that may be designed to protect young people can raise not only questions about those young people's own rights, but about the rights that adults have when it comes to speech and privacy.
Welcome to the Regulatory Transparency Project's Fourth Branch podcast series. All expressions of opinion are those of the speaker.
Hello, and welcome to the Regulatory Transparency Project's Fourth Branch podcast, episode number 84. Today, we're joined by Dan Mornoff, Executive Director at the American Civil Rights Project, and Giancarlo Canaparo, Senior Legal Fellow at the Edwin Meese III Center for Legal and Judicial Studies at the Heritage Foundation. Moderating a discussion on the changes of DEI policies under the new Trump administration is our moderator, Linda Chavez, who is the chairman for the Center for Equal Opportunity. Thank you all for joining us today. Thank you, Linda, Dan, Giancarlo. In order to get right to the discussion, I'll hand it off to our moderator, Linda. Thank you, Linda.
Thank you very much, Marie. And I was going to go into long descriptions of our two illustrious guests' careers, but I think instead we've got a limited amount of time that I want to jump
DOGbackwardsss suggested pass
to the executive orders. The new Trump administration has been very, very busy over its first couple of weeks. And one of the clear first priorities was to take on the issue of diversity, equity, and inclusion, and the way it has transformed civil rights and civil rights enforcement, particularly over the last 4 years during the Biden administration. There have been, I don't know, somewhere between 9 and 16 executive orders, depending on how you count them. Some have been issued as EO, some have been issued as memoranda. We're obviously not going to be able to cover all of them. But I will cover just the initial action, which was ending radical and wasteful government DEI programs and preferencing. And I'm going to ask Dan if you could go into that.
Sure. That particular order, which was one of the ones entered on the first day, started out with the declaration that the Biden administration had forced illegal and immoral discrimination programs, and that ends today. That was the terminology used. And then it proceeds, and I think a lot of these are going to follow this pattern after having a declaration of policy with a series of
time-sensitive requirements for how the federal government's going to follow through on this. For this one, I think there are 4 that are worth particularly flagging as things that the order requires. The first of those is for the Office of Management and Budget, along with the Attorney General and the Office of Personnel Management, to coordinate termination of all discriminatory programs, to review all employment practices, union contracts, training policies, or programs across the entirety of the government. That one seemingly will be an ongoing structure for how the rest of this will unfold. A second one, every agency within 60 days must terminate.
No
I like this
way.
language because it actually captures the degree of discretion available to a president in an executive order. Requires them all within 60 days to terminate to the maximum extent allowed by law, which I'm sure that others will explore, all DEI or environmental justice offices, positions, equity plans, initiatives, grants, contracts, and all DEI performance requirements for employees, contractors, or grantees. We're going to have a big one. Also, in those same 60 days,
You both say dumbasses.
Backdated to November 4th, provide a list of all DEI and environmental justice positions, committees, programs, activities, budgets, and expenditures, and also services. Also to list every effort undertaken to hide any of those things in the interim. That's why they backdated this to November 4th. All DEI training contractors and materials, all grantees funded to provide or advance DEI or environmental justice programs, services, and activities. Oh, and also to assess the cost profile of all of those programs and policies, presumptively so they can be folded into something like reconciliation. The last one flagged on this was all of the agencies. They're required to recommend actions to be taken to adhere to the policy stated, including expressly notice to Congress of unconstitutional things that they don't intend to do anymore, as well as policy changes or regulations to be pursued and guidance to potentially be advanced in the future.
Well, that's pretty comprehensive. I should have said that also on the first day, they issued one sort of very broad, sweeping executive order, which was essentially a rescission of harmful executive orders and actions that had gone on in previous administrations. They are way too long to list. They cover a huge variety of programs, even Medicaid and the Affordable Care Act, migration on the border, rebuilding and enhancing programs to resettle refugees, promoting access to voting. There are just a ton of them. All of these, I should note, are available on the White House government site, where they do list all presidential executive orders. Giancarlo, I want to turn to you because one of the things that you wanted to talk a little bit about was the whole question of the changes that are going to be required in terms of government hiring. So maybe you can talk a bit about that.
Sure. So also on the first day, there was an order called federal hiring processes and restoring merit to government services. And this order did two things. And actually, the focus on race-based hiring is a small part of it. The order really takes issue with how inefficient the hiring process is. It takes ages to get hired. There's very little communication. So about 2/3 of the order is just sort of reforming and making more efficient the hiring process. But the beginning of the order focuses on DEI hiring preferences. The administration describes current hiring practices as broken and not focusing on merit, skill, or dedication to the Constitution, and says that instead current hiring practices reward people that express a commitment to equity and to gender ideology. So the Office of Management and Budget and the Office of Personnel Management are going to put together a new federal hiring plan which will prioritize commitment to improving government efficiency and will prioritize hiring people who are passionate about the ideals of the American Republic and of
I don't like shit about that.
also forbid union bosses for race
They're like tigers.
hiring.
Move. Back up. You're doing too much. I'm about to punch you. Move, girl.
All of those are obviously very sweeping. Let me play devil's advocate for a minute. This is a new administration coming in, elected by the people with the largest amount of votes, and most of the people who went to the polls said they wanted the administration. I think most analysts would agree that probably the issue was most on people's mind. Certainly DEI was a prominent issue in some minds. There were lots of commercials, for example, during the campaign that were critical of then Vice President Kamala Harris's own to talk about transgender issues, for example. But this is a lot of emphasis on DEI. Is it too much? Is this too much emphasis in the first few days of the new administration? Could it be described in any way as overkill? Dan?
Come on, back up. Move, because ain't no reason for you right here playing. Move.
That way, but I think they would be wrong. I think that the administration has made fairly clear and had made clear before the election, so I don't think there's any bait and switch going on. So one of its real commitments was going to be
about to quit. Don't quit either, dog ass backwards.
More traditional pushing what I would describe as illegal discrimination across the entire country, much less in its actual programming. So the fact that the president has, among the earliest things he's chosen to do, is focus on getting all of the government on board to actually stop discriminating and start enforcing civil rights that had been ignored or misinterpreted by his predecessor. Seems to me to be entirely appropriate.
Let me follow up with you, and then you can add on to what Dan said. Again, play devil's advocate here. What about the notion that basically a way to control the way people speak, the way people think,
You see my name on the game?
Regulations, programs, and simply do an AI search and find the word diversity wherever it occurred, equity wherever it occurred, inclusion, simply change that. And in the process might shoot,
that's how come so about
getting rid of properties of those terms. Biodiversity, for example, means something very different than the kind of diversity we talk about in hiring.
I'm not actually worried about that in this case, and the reason why is because in every of the orders that President Trump has issued on DEI, and in his speeches, notably his Inauguration Day speech, what he's targeting is civil rights law. He's not interested in lingo as such. He's not interested in people who use the buzzwords, but he's interested in, and this is a direct quote from the order we'll touch on next, I imagine, where he's going after DEI in the private sphere. But this is
my niggas coach football. I don't know nobody that's really in the basketball.
Civil rights laws, right? So if a company under these orders, if a company called something diversity, equity, and inclusion, but didn't do anything that was discriminatory, don't give the government any impetus to go after that sort of thing. And frankly, the government is going to have its hands so full with actual discrimination there's not going to be, I mean, it's not going to catch but a fraction of it, I gather, is my estimation. So I'm not worried about wasting resources going after maybe obnoxious. Maybe in some people's mind that this emphasis on DEI is being anti-civil rights. This is a debate about civil rights laws. So let's talk about that for a few minutes. Do these EOs in any way countermand Title VI, Title VII, any of our civil rights laws that guarantee equal opportunity, non-discrimination?
No, and in fact, very much they are the opposite. They are in fact ordering and directing how the federal government should be much more actively enforcing its mandate under those statutes to root out illegal discrimination in the federal government and its various regulated communities.
John Carlo, you want to?
Yeah, let me just add, Trump has taken a position which is emphatically not the libertarian position, which is that we should just leave the issue of discrimination to the marketplace. He has regularly, and again, routinely in every one of these orders, re-emphasized that enforcing the Civil Rights Act is the priority. So it is a focus on discriminatory conduct that he wants to weed out. It's very clear that he intends to do so. This is not a hands-off approach. This is going to be off because I've been
but I like it.
With respect to what you might call trendy discrimination, the sort that Harvard did in the case that got it to the Supreme Court, discriminating against Asians on majority, for the phrase that often came up in the Harvard case is white adjacent groups, and those could be discriminated against. And Trump said in each of these orders, the law applies to everyone equally and will be enforced.
No way.
Let's talk a little bit about the federal government and the personnel in the federal government, the offices in the federal government. Then let's talk a bit about the private sector. Which of you would like to take the federal government? Dan?
No.
I'm not sure that these break down very easily that way.
Okay.
This nigga used to be a crash shop.
Sure.
Like, I was calling the question about something that's going on there, right?
That was entirely,
I said, you didn't have that. This person, like, didn't come up with this combination. I'm glad you got help. Like, kids, they liked him. Like, it didn't seem like they couldn't leave. Like,
governmental venues.
I don't know what type of plans y'all got. He like, shit, y'all might as well just go ahead and get it and all this stuff. Like, he's saying all this shit, and I'm just thinking, like, a couple years ago,
I don't think it was about 20% of the U.S. economy is directly governmental spending without downstream multiples and effects that whether or not you're currently a government contractor, if you're running a civil rights laws that are a condition for participation.
You breed our dog. That's why it's called FTG from the ground up.
When you're talking about changes in governmental purchasing, it's much more.
I don't know. He's like, dog just died. I was like, whoa.
I told you him and Taku. I know of it. I know about the roots.
There's that. That's true. Whether you're private, public, you're covered.
talking about hiring processes. If you're the chief executive of the executive branch, you can call the shots to a certain degree within the law, within regulations, in how people are hired and appointed, and whether they can keep their jobs. This administration may be pushing the envelope on this, but at least in previous administrations, it wasn't that controlled by civil
Talk like a
rights.
man, basically using that
So
computer.
obviously, if you issue an executive order having to do with hiring practices in the federal government, you have control of that. Things change the emphasis on race preferences, for example, pretty easily. It's a little more difficult in terms of the private sector. It's not that Title VI might not cover some of these private sector employees. Contractors. It's not that Title VII doesn't apply to almost all of them. It's going to be something different. It's going to be extreme. It's going to take you don't expect in our kind of free market economy that every HR director and every company in America is going to take these executive orders and see them as directive from the CEO, for example. So that's more what I was talking about. Carlo, do you have any comment on that?
Hey, let's go.
Briefly about within the federal government, because that's, I think,
anything about it is crazy because we're talking about I don't ever talk to him about what it is that I got to do.
So one of the things he did is he said
always say something
official within the government
without knowing what the fuck going on.
Leave. The subtext being until we can, figure out how to fire you. But stop you from doing your job. If your job is to impose stuff on the government, you can just do that through his secretaries and his officials at the stroke of a pen. And likewise, if you are a DEI professional and you're looking for a job in the federal government, you're not getting one for 4 years. And that's
63.
But it's
Give me that ball, man. Nah, I'm winning. Being shit out of his leg. Just phone that ball and I'm supposed to be
two sorts of entities.
Dumbass shit.
Entities which are those covered by Title 6 and 7 of the Civil Rights Act. So Title 6 applies to anyone who gets federal funds. That includes almost all of them, with the exception of a handful. Federal grantees. You've got Title 7 applies to any employer of any significant size. And they and I'm not sure this is Title 7. And now what Trump has announced for those entities is that there's going to be really robust if you have any DEI policies that violate the law,
shut him out. You ain't getting shit.
Looking for you and they come after you. So that sort of raises the question, like if you're the HR director, right? What of my DEI policies are going to be problematic? And I think I put together a short list of ones I think that the federal government's going to be coming after. These are things. Now bear in mind, cleared the air with respect to what exactly the text of Title 6 is. Title 6 says no discrimination. Basically, the fairest reading of it is really if you are taking federal funds, if none of the
what's up? Hey, for real.
And then Title 7 says firing and conditions of employment, no discrimination. So
shit, you cannot get in here.
That means things like race and sex-based resource groups within a company that where if you into this group. Same with mentoring and
and I watched it with He said something about a lot of
segregated training, a lot of DEI training work.
or another, so find another word, something like that.
And then this is an interesting one that I've noticed a lot of savvier companies do, especially
Say it again. Say it again.
around civil rights law. But what they do is they will give preferences in employment applications for people
No, we got nothing.
I don't think you can do that.
You're not intelligent enough to use another word. You found another word.
What cannot be done directly cannot be done indirectly.
My belief, that's how you know people get it.
The last target for civil rights
I was always
easy.
I said cuss words express like me. So imagine all this time
Before you say cuss word, before you say word, what's the first thing you say?
So I think those are the sorts of
Curse,
categories that are
right? What is it? We all know what a curse is, right? It's a curse word, bro. We've been cursed from birth with this type of language. It's a curse that once you become,
there's a widespread practice in
you know, saying, smart enough to know what the hell is going on. You know what I'm saying? Like, you have to change and do something about it. Like, it's a curse. It's stuck in something that's hard. That's why it's a curse word. You know, profanity, bad words, words that we shouldn't use.
In who works for them, or who they promoted, or who they're contracting with as third parties, which is illegal. But, you know, I would hope the federal government is going to be focused on a lot of those kinds of policies as well. Rooting out and extinguishing.
There's probably some things that our parents didn't know. We gotta look at it too. You know, there's a lot of stuff that they didn't know.
But it'll still make you look back at the end of the day.
Sure.
You didn't know?
The short answer is yes. The best case that's out there for this is a Fifth Circuit case called Xerox. I'm trying to remember. I don't remember the rest of the name of it. Honestly, it's been a little while. Was that have a system that rewards executives for racially balancing, and someone complains that, yeah, in fact, that is a violation for the executive compensation.
And do you think that this is going to spur lots of new lawsuits and that it will in fact be litigated and maybe make it all the way to the Supreme Court, as we saw in the case of the universities, where we finally got a decision a couple of years ago that did shut down racial preferences, or at least we think it did. We're still monitoring whether that's the case.
Yeah. The short answer is that yes, I would expect that eventually the plaintiff's bar, because it is really interested in money, even more interested in money than it is in faddish discrimination, is going to follow where case law points it, or maybe more to the point, follow where the EEOC points it in telling them, no, we really do agree that this is illegal. We're bringing big case X against whomever. You might want to bring the same case also. Eventually, those incentives are going to move action.
Yeah, I think you may also see, over time, a shift in the traditional divide where, plaintiffs' lawyers are almost always Democrats or progressives, right? Because now there's an enormous incentive if you're a conservative, civil rights-minded person to just start doing some plaintiffs litigation. Actually, a friend of mine, the moment this EO dropped, called me and said, "You want to quit your job and start a plaintiffs firm with me?" And I said, "No, but go forth and make a killing," because the opportunity is there right now.
Let me again try to put on my devil's advocate hat and look at this. When we think of civil rights enforcement, since the 1964 Act, the kind of discrimination that was being rooted out, well, yes, it was colorblind. It was supposed to be colorblind. You were basically not supposed to use race to make a decision about who to hire, who to promote, what to pay them. But it was seen, at least initially, as rectifying wrongs that had been committed against Black Americans, Latinos, and others. Most of these orders seem to be aimed at trying to stop what, in the old parlance, we would call reverse discrimination, where you're discriminating against whites in favor of Blacks, Latinos, and others. Reverse discrimination, where you're discriminating civil rights laws. I'm assuming Latinos and others. Reverse discrimination against land, and that everyone's heart is pure, and that there's absolutely no. I'm assuming against Blacks or Latinos. There clearly still is. And so what's it going to mean in terms of enforcement of those laws?
I'm quite sure that people will continue to bring claims, valid claims, also invalid claims. There are a lot of bad discrimination claims that are brought, and I assume that will continue. But there are also a lot of good ones that are brought, and I assume that those will continue. The plaintiff's bar is not going to stop bringing those either. The whole point here is that the law still applies in all of the situations you're talking about. It's just that the administration is acknowledging that when Congress wrote our non-discrimination laws, it wrote non-discrimination laws. And non-discrimination laws protect everyone against discrimination. So, in fact, when you systematically ignore, as the last administration did, the large-scale discrimination by very large companies, also smaller, but, of rectifying societal discrimination, I think was the term that was used by the Supreme Court for decades. That's never legitimate. You can't actually do that. You can engage in legally, and you have been able to for decades, you can legally discriminate in order to fix the harms caused by your own recent history of discriminating in a traditionally segregated part of your workforce.
Right,
That's
and actual,
as it has been.
Right, actual victims of discrimination can be made whole. So even if that means, a white got the job that should have gone to a better qualified Black applicant, and, you've got to now give it to the Black applicant, and that means the white may be out of the job. You can do that.
Right, but you have to do that. And, so if you're not doing that, and instead, like I'll pick on Dropbox. Dropbox had a published policy that it was going to, it wanted its workforce to reflect the diversity of the world in all its dimensions. And they didn't peg it, and not only did they not peg it to the demography of the United States, which would have been irrelevant because it, actually you have to, in Title VII world, care about who is qualified and interested in taking your job. But they didn't even do that. I mean, they're hypothetically pegging this to world population. By the way, the one group they're most clearly discriminating against is what they score as Asians. By the way, if you're actually trying to peg your workforce to the demography of the world, more of the world's population lives in East Asia, South Asia, and South Asia.
They talk to me in love, just make sure you have to go to the floor. They tell jump on the money, get your back down. Party get the party playing with his nose down.
Just a minute, Giancarlo. You wrote a wonderful paper about the civil rights laws.
Salutations! It's your Uncle Sam, and this.
Launch into that by referencing, the phrase you pulled up a moment ago, reverse discrimination. And the simple fact of the matter is there's no such thing, because what the civil rights law targets by its plain terms and by the manifest intent of the people who wrote it and signed it is that what it's targeting is the act of treating somebody differently on an arbitrary basis, which race is. It's that act of choice which is immoral. It's not that, it has nothing to do actually with the color of a person's skin that the law is targeting, right? If I fired an employee because I sincerely thought that he was Martian, even though Martians are not a protected class, the act that I have done in choosing to treat him differently on an irrelevant basis is immoral. And that's what the law is targeting. And so the law is trying to teach people not to make that arbitrary and immoral choice. And it doesn't matter what the color of the person's skin is. So when you say, you know, what does this mean for our old understanding of civil rights law? It means we're returning to an old understanding of the civil rights law, that the law is neutral, that justice is blind, that everyone is treated equally, and that you don't have the liberty to discriminate against somebody on an arbitrary basis.
We've talked a lot about race in this first half hour, but some of these executive orders, some of the most important ones, I think, have to do with sex, or as progressives would like to call it, gender. But I think we've now reverted back to calling sex sex. Dan, you want to talk about that for a minute?
Yeah, one of the, again, first day orders, this one was, its full title was Defending Women from Gender Ideology, Extremism, and I could probably tell an awful lot of its content just from that title. Again, it follows the same structure of having a policy statement, and after the policy statement, having a whole laundry list of things that will require the agencies going forward. For accuracy, here's what the policy portion of this was. We will be basing federal policy on, basing federal policy on truth is critical to scientific inquiry, and trusting government. The president now recognizes the immutable biological reality of sex. Women are biologically female and men are biologically male. It recognizes there are two sexes, male and female, not changeable, and are grounded in fundamental, incontrovertible reality, and states that the executive branch will enforce all laws to promote this reality. There's a lot of commentary below as to how they're going to achieve that. I can roll through that if you want. We cannot. There are like 11 action items, but the commitment here that the president has made for the government, whether through guidance, whether through regulation, and it does specify in a few places where regulatory changes will be necessary.
No way. Wow.
Across the board is to disassociate the federal government from what it defines as gender identity and gender ideology, and to return, as by the way, in the Title IX sphere, where there was just this extensive fight unfolding across the nation's courts, which seems to have now ended. I think in, 8 for 8 courts of appeals, as far as we got rulings, and the Supreme Court, we got rulings that, no, actually, Title IX is about sex, not about gender, or something approximating that, whether or not it's really fair to say the Supreme Court got quite that far. But the president, in accordance with all of that, is going back to saying we are going to enforce Title I and Title VII and all of the other non-discrimination laws that are relevant. But we're going to do them for sex, focusing on sex, not on this other concept, which is entirely, what was the phrase they used? Entirely, fully internal and subjective as a sense of self.
It's amorphous, right? It really is. It's very difficult to define gender. And there are disagreements even among progressives about how many genders there are. In particular, when you're writing laws, it seems it's very difficult. If it's all in the mind, not of the beholder even, but of the initiator, I guess, it's very difficult.
Wow.
Executive orders, or at least one, having to do with indoctrination of kids in K through 12. And wonder if either of you would like to weigh in on that.
I bet we really don't have time to do so in any depth, but there was this K through 12 order. There's also one about anti-Semitism. There are a whole slew of them that are issues specific to the military, which is interesting because they tend to overlap with those we've already to specifically say it for the military, but, you know, more power to you.
Yeah. Yeah, in the last few months, I realized I never got to the second point. Let me just briefly summarize what that does. So it ended an order from Lyndon B. Johnson, which established that government contractors need to have affirmative action plans. Now, at the time, that meant something very different than it means today. That just meant you need to show why you opted. Over time, the federal government morphed that into you need to show preferences and meet quotas, et cetera, et cetera. So that's gone. And then this is where things get really interesting. New federal contracts and grants will now include two provisions which say, A, we promise, federal government, that we are not discriminating in violation of the civil rights laws, and we promise that we have no DEI policies that violate the civil rights laws. Federal contracts and grants is because it makes those contracts and grants, it makes that term subject to the FCA, the False Claims Act, which means that you can be sued if the federal government finds out that actually you do have discriminatory DEI plans. The federal government can sue you. Private parties representing the federal government can sue you and get part of the government's recovery. It's called KETAM actions. And you can be subject to non-payment on your contracts. So that really ups the stakes for anyone doing business with the federal government.
Those aren't just damages of like disgorge the money you were paid. It's triple plus a statutory fine for every individual transaction they paid based on it. I think that statutory fine is yeah, so if you're talking about something like a suit that was brought, let's say a phone company had a discriminatory DEI program, you've seen a phone bill. You've seen every line item on that. Every line item on that is getting tripled, and every line item on that is carrying a $5,000 to $10,000 fine as a separate transaction. Those numbers will be astronomical.
I don't know, Giancarlo, maybe that friend of yours who called and wanted to know good advice to take some. A lot of money to be made here. 11246, the history of that is very interesting, and having been gone from the U.S. Commission on Civil Rights White House during the Reagan years, there was a working group put together during President Reagan's term to discuss rescinding 11246, but rewriting it to make it clear that giving preferences on the basis of race was not permitted. It died, unfortunately. It was considered controversial, and it died. But when you're talking about employers, particularly anybody who does any kind of contracting with the government, I have sat on several boards, corporate boards, and I will tell you that visits from the Office of Federal Contract Compliance Programs at the Department of Labor are anticipated with fear and loathing in many companies, because they do go in and can make life very difficult, and it has gone way beyond simply encouraging people to take affirmative steps to recruit people on a colorblind basis, but to give opportunity to people who might have been neglected in the past. It's gone way beyond that, to actually putting in place numerical goals and timetables which end up operating like quotas. So I think that that is going to be very interesting, and I want to ask either one of you if you know the answer. Since we now have this executive order rescinding 11246, is that going to mean that the Office of Federal Contract Compliance Programs has any legal authority to continue to do the work that it's been doing?
I know that this order that took out 11246 also assigns tasks to OFCCP. So seemingly they intend for it to still exist. One interesting detail is that 11246 is the order that created the OFCCP. And this order doesn't actually say anything granting it continued viability. I haven't really seen this discussed, and I certainly don't know the answer. But I think it's a fascinating question whether that means that the office no longer exists at all. One of the things that Doge was talking about right at the outset was whether there's a legal distinction between agencies of the government whose authorization by Congress has expired and those that haven't. Like, regardless of what you think about whether the president has the constitutional authority to impound funds for authorized agencies that have been appropriated money, you might have a very different answer where the agency has no legal existence and it's just still churning along because Congress, wrote a check to something that's hypothetically defunct. Whatever the answer is to that, I think that it might be an interesting one. It has to be more dramatic here, where there is no authorizing statute at all. It exists only because of an executive order, and an executive order that has been revoked. Like, I don't know the answer. I'm not sure we'll ever find out the answer. It might be fascinating when a company gets that call telling it has an audit for, I guess, the new requirements of what OFCCP is going to be policing. If they simply said, we're not going to comply because you're not a thing. I don't know why I'd want to make that call for them as a lawyer, much less an officer or director. You might have some very hefty penalties that kick in, but if you did, you might in fact win.
Yeah. Giancarlo, anything you want to add on that, or?
No, that's, I defer to Dan's summary on that.
Great. Well, we only have a couple of minutes left, and so I'm going to give each of you a chance to just briefly sum up what you think the effect of these executive orders is going to be. Is this as much an effort to change the culture as it is to change practice? I'll start with you, Giancarlo.
Yeah, to answer your question directly, I think with respect to is this an attempt to shift the culture? Yes, and I hope it is, because although I'm a lawyer, I actually have a pretty dim view of the raw power of the law is, and I think if anything, particularly the Biden administration and the way that they just refuse to enforce the civil rights laws neutrally, and allowed a culture of disobedience to the civil rights laws to permeate. Having good laws on the books isn't enough. You need a culture that believes in them and is willing to enforce them. So I hope so. I hope it does shift the culture, and I hope that I think the orders alone are not going to be enough. There's going to need to be a robust enforcement and a continuing public education campaign.
Let me just follow up with you, Dan, and ask you a slightly different question, and that is, do you think we're going to see any sort of massive resistance changes, challenging whether or not these executive orders are within the scope of the president's right, or just other forms of resistance?
Sure, and I'll come back to the last thing that Giancarlo had actually said as well in answering this. I think these executive orders, they are a great list of things for the agencies to do, but they're just a list. Things haven't been done yet. We're going to see massive resistance. There are already lawsuits that have been filed challenging the orders. They're mostly going to lose. They're going to lose because the orders are actually well written this time. Order agencies to do things. When the agencies do things, we're going to have a whole other round of lawsuits because there will be affected parties who will have standing to be able to complain about them. But right now, people are just mouthing off, and I don't expect the cases filed now to be very material. But we are going to have to fight inch by inch through all of the institutions across all of the we need this have to engage in legal systems equivalent of house urban combat to take out an embedded system. So we'll have to do that. And I guess found the world's best cheesecake recipe, but you can't eat a recipe. You actually need to bake it. So where we are right now is that the agencies are baking, and they've got a lot of baking to do, and we're going to have to fight the whole baking process and then to defend the cakes. And then we're going to have to go a whole whole lot further, because there are a whole lot of things that, while these are a great list, and I'm very happy that they exist, there is a lot more that is going to need to be done, and a lot of it's going to have to involve Congress as well. Because there are things that are wrong with our laws that we really do need to get right in ways that the president almost surely cannot fix.
Yellow!
Well, thank you both very much. I think this has been a very enlightening and broad conversation, and obviously it's not going to be the last conversation on this topic because, as Mr. Dan has suggested, it is going to be what these executive orders essentially comprise.
Here we go!
But we're going to have to see it on the field, and we're going to have to see what ends up happening. Thank you both very much, Giancarlo Canapero and Dan Mornoff. Thank you very much for being our guest today.
Thank you for having us.
Thank you.
Here we go, shot! Ready?
Catch every new episode when it's released. You can subscribe on Apple Podcasts, Google Play, and Spreaker. For latest from RTP, please visit our website at regproject.org. That's regproject.org.
This has been a FedSoc audio production.
Down! Hot, hot!
My name is Marco J. Lloyd. Today we're excited to host a litigation update on Amazon, the National Labor Relations Board, and captive audience meetings featuring William Messenger and Roger King. Bill Messenger is Foundation Vice President and Legal Director at National Right to Work Legal Defense and Education Foundation. He was a staff attorney for over 20 years, and during that time represented individuals in numerous cases that sought to expand worker freedom of choice. This includes acting as lead counsel in 3 cases before the United States Supreme Court, including successfully arguing Janus v. AFS CME Council 31. Our moderator today is Roger King. Roger is Senior Labor and Employment Counsel for the HR Policy Association. He's also served as partner at Jones Day, Captain and Legal Services Officer in the United States Air Force, and Professional Staff Counsel for the U.S. Senate Labor Committee. He testified for Congress and represented employers in many high-profile labor and employment law cases, including co-counseling the winning side of the land If you have a question at any point in today's program, please enter it into the Q&A section at the bottom of your Zoom window. We'll do our best to answer as many as we can. Finally, we'll note that as the Federal Society for legal or
Hey, we're good.
Thank you for joining us today. The floor is yours.
Hey, 43, 15! High side! Rolling. Hey, yellow, hey, go going. High side! Attack, get on the ball! High side!
No.
So just sort of, it's interesting to know the history of it, because, you know, the captive audience meeting case that we're talking about here, the Amazon decision, is really part of a larger sort of NLRB censorship. Employer speech is permissible under the National Labor Relations Act, and the mandatory meeting is sort of a small part of it. So to sort of get the bigger picture, it's good to know about, you know, Section 18, how free speech is sort of developed under the Act. And the Act, as originally written, only actually gave a right to unionize, and the original board back in 1940 took the position that employer speech.
Hey, 57! High side!
However, the Supreme Court said that violated the First Amendment or Virginia electric power. You can't basically censor all employer speech about unions and unionization. Eventually, after that, as part of Taft-Hartley amendments in 1947, Congress actually added something to effectuate the First Amendment within the National Labor Relations Act, and that's known as Section 8C. The expression of discrimination shall not constitute an unfair labor practice, absent a threat or promise of benefit. So 8C was the idea that that's a statutory sort of restriction on the board's authority, which was ready, set, the ability Panther 60, Panther 60. Ready, ready. As a result of Section 8C, the court has sort of said ready, ready. Uninhibited speech about unions and unionization. However, notwithstanding that, the NLRB for the last 70-some years has taken a very restrictive view of 8C and has often found a lot of ways to try to restrict employers' ability, ability to take refuge under that statute. And so okay, great. Generally done is again, Section 8C basis speech is permissible unless it carries a threat or a promise of benefit. Well, what the NLRB has often done is basically said that just about anything that carries with it or an unstated and implied promise of benefit, and therefore the NLRB has the ability to censor. So before we talk about the mandatory meetings, an example comes out of the Amazon case that we'll discuss in a minute. Amazon had an open door policy, and it basically told employees, we have an open door policy. If you have any concerns about unionization or about wages and terms of use of employment, you have an open door, you can speak to us. The board said that any solicitation of grievances, something like that open door policy, carries with it a legal presumption that it carries with it a promise of benefits. Let go! So 8C again is supposed to effectuate the First Amendment, is supposed to protect and free speech under the Act, but as a practical matter, the board has largely gutted it over the last, since it's been national. One question we'll talk about later in the future is whether or not it's possible to breathe more life into 8C. Just sort of moving forward, that's sort of where we stand. Got it. Ready? With respect to speech under the Act. Let's go now. Let's stay with 8C. Go. Reacting to case law, reacting to a previous prohibition on employer speech regarding unionization. So the legislative history, as I recall, doesn't have a great discussion, any in-depth discussion regarding... On the set! But what's your take? Congress recognize that as a result of 8C then being included in the Act? Yes, that's the way the Supreme Court's interpreted it. Chamber of Commerce versus Brown, the most recent decision, said, viewed one way, Section 8C implemented the First Amendment under the National Labor Relations Act. And that, makes sense. I mean, obviously, the NLRB can't restrict speech to the extent it violates the First Amendment. So for 8C to really have meaning, it basically effectuates the First Amendment as a statute. The NLRB can't violate, censor speech in a way that violates the First Amendment. They just did that under 8C, which, if anything, can't be narrower than the First Amendment. If anything, is broader. It's like a prophylactic, sort of prohibition on, NLRB censorship. That absent a threat or a promise of benefit, that's not speech that the National Labor Relations Board has authority to suppress, as a statutory matter. And I would personally and professionally agree with 8C. For those of you that have joined us today that don't regularly practice under the National Labor Relations Act, do take a look at 8C. It's a very important provision, and as Bill just mentioned, it certainly codifies and even, I think, expands, frankly, free speech rights in the workplace. This is free speech not just for employers. We need to make that clear. It's free speech for unions. It's free speech rights for all stakeholders under the Act. And I think, Bill, as you said, the court's been quite clear that robust discussion regarding workplace issues and issues surrounding unionization, pro or con, are encouraged and supported by the courts. Is that a fair conclusion? at least in terms of their general statements, the Supreme Court has made very clear that the uninhibited, robust debate, is encouraged in the act. There's supposed to be free speech. But unfortunately, anyone here is a labor practitioner knows, as a practical matter, that's not the way the board has enforced it for quite a long time. I mean, the NLRA, you go through labor law, it's a minefield of any little thing, usually an employer can say, can be deemed illegal under the act, depending on how it's phrased, how it's taken. The board itself has said it has broad discretion to determine what speech is unlawful. Is it, in the totality of the circumstances, have a reasonable tendency to coerce employees? Is sort of the standard the board has declared for itself. And the idea being that also the actual effect it has on employees doesn't matter. The employer's motive doesn't matter. Does the NLRB declare as a matter of legal fiction that speech could have a reasonable tendency to coerce in the totality of circumstances is how the board believes it has the authority to control speech under the act and present. And again, as mentioned earlier, with HC, the way the board is around is all kinds of different types of speech carry with it unstated and implied promises of benefit or threats, even if it's not actually there. So I think the promise of HC really hasn't been realized. By the board for quite a long time. Eventually, HC is going to need to be interpreted consistent with the First Amendment and the Constitution. Hey, we're good.
Totally agree. I mean, the Constitution's going to override any board decision. Well, let's go to the case before us today. Very important case, probably one of the most important cases in decades coming from the National Labor Relations Board and its ramifications. Bill, set the stage for us, then I'm going to intervene and ask a few questions.
Sure. So the bottom line holding of Amazon is that it's illegal under the National Labor Relations Act for an employer to have a mandatory meeting to discuss whether for or against unionization. So the idea being that an employer requires its employees on paid work time to attend a meeting where unionization is discussed, that's illegal to require the employees actually to attend that meeting. So that's the bottom line holding, but there's a long history of what sort of happened. Just sort of go back. This is going back to the 40s in a case called Clark Brothers. Before Section 8C was enacted in 1947, the board said these mandatory meetings are illegal. Rolling. Congress responded in 1947 with 8C, and among other things, in one of the legislative history reports, said that Congress expressed displeasure with Clark. So after that, in 1948, came a case called Babcock. And in Babcock, the board said mandatory meetings are not illegal based upon 8C. This is right after 8C was enacted. And then for the last 76 years, mandatory meetings have been considered lawful under the Act. So it's been sort of, nothing has changed. There's one little blip in the 50s where the board said you had to give a mandatory meeting, but the courts reversed that rather quickly. That would never survive constitutional scrutiny today. But other than that, since Babcock in 1948, employers have been allowed to hold mandatory meetings to inform employees of their views about until 2024, all of a sudden, the Biden majority declared, we've been wrong for 76 years. Mandatory meetings are actually illegal under the Act for a variety of reasons. We can discuss. I don't know if you want me to start diving into it yet.
So, Bill, we've had 76 years of precedent overturned by this decision. Is that a fair conclusion?
Yes.
And Babcock and Wilcox had been the law both under Democrat and Republican parties for decades.
Yes.
Fair conclusion?
Just all of a sudden, until 2024, the board says, you know what, we've been wrong all this time. Change position.
Well, and I think it's important under both Republican and Democrat boards. This hasn't been just a Republican board position. This has been a position in the National Labor Relations Board under various administrations for, as noted, 76 years approximately. So a very significant
Here we go!
From established board jurisprudence. Well, let's dive into the reasoning of the majority for a moment. And then I want to go from there to what we expect maybe in the circuit courts as this case is challenged. And by the way, for those of those of you who have joined us today. Bill, this case is on appeal, correct? It's in the 11th Circuit?
Yes.
And we'll get back to the significance of that in just a moment. But Bill, I'm looking at page 13 of the majority decision. And it's interesting. Pardon me, I'm going to quote for a moment. I'm a little bit on sessions such as this, but I think this is important. This is the majority. Quote, captive audience meetings intrude on this protected sphere of employee privacy and autonomy and reasonably tend to interfere with employees' Section 7 rights in at least 3 distinct ways. And we'll dissect each one of these. Continuing to quote, first, captive audience meetings impinge upon an employee's Section 7 right to choose, free from any employer coercion, the degree to which they will participate in the debate concerning representation. So that's the majority. How do you react to that? I have some thoughts also. Rolling. I'm curious as to your reaction to that argument.
Sure. I think it's rather weak because Member Kaplan, so just there's a dissent in this case by Member Kaplan, and so like a lot of this, we can talk about the majority held and what Member Kaplan said in dissent. So this, is one of the, grounds on which, as you mentioned, the board said this interfered with employee Section 7 rights, namely requiring them to attend a mandatory meeting. In a debate, the majority said just read. And as Member Kaplan said, employees aren't required to do anything. We're good. They're not required to participate in a debate. 15. They're required to attend the meeting. They're actually, 15. They're being paid to be there. So, this is something the employer can control. It's not like they're off the clock. And so, employees aren't being fired. They don't have. In fact, it would be unlawful under the act if the employer actually made the employees, say something or do something, during these meetings. All the employees are doing is just listening to the employer's views on unionization, perhaps learning more about it, and that's not interference with Section 7 rights.
No, and I agree. Trying to restrict participation, or at least listening to and understanding the issues associated with unionization and the free and robust exchange of ideas, is what I think AC is all about. At least one can make that argument. Certainly that's what the First Amendment is about. And I know the employer community has felt over the last 4 years particularly that the board has seemingly stretched as far as possible to cut off debate, cut off discussion, restrict the rights and opportunities for employees to hear all sides of the issue. And to me, that's concerning. Put aside whether you represent unions, employers, employees. Debating free speech is something we hold sacred in this country, and we ought to be encouraging the exchange of ideas, not discouraging. Well, let's go to the second rationale. Again, I'm reading from the majority opinion. I'm now at page 14. Second, captive audience meetings readily serve as a mechanism for employers to observe and surveil employees as they address the exercise of employees' Section 7 rights. So the so-called surveillance discussion, issue, and argument. How do you respond to that, Bill?
With what Member Kaplan said, in any kind of in-person communication, by definition almost, you're going to have the opportunity to see how someone responds to, the position, the speech. So almost any time an employer engages any kind of in-person communication with employees, by definition almost, the employer is going to be able to see how people react to it and do wrong. That's not going to under the act would make any kind of in-person communication illegal. And then also that falls far short of what the board considers real surveillance, in violation of the act, which would be like videotaping people, something like that might chill their exercise their Section 7 rights because they think they're being watched. But merely to say we're going to put on a presentation that's, expresses the employer's views about unions doesn't constitute surveillance because maybe, potentially, the employer might get some idea of how people think about the union based on their reaction. And then, of course, if the employer actually did engage in surveillance during one of these meetings, by saying we want everyone to say, what do you think? That would be an unfair.
Ready?
So, captive audience meeting, constant surveillance is incredibly overbroad.
No, I think that's a very sound response. And let's just explore that for a moment. The board also talks about, and I've heard this from reports of board members' presentations, if a meeting that an employer is called, mandatory meeting, let's say, starts out just to talk about scheduling issues, talk about quality performance issues, and then starts to go in the direction of include a discussion regarding unionization, employees have the right to excuse themselves. It seems to me at that point, then the employer would have some ability to see who may be opposed to the employer's position. And there you might have surveillance, but that to me makes no sense whatsoever in this whole surveillance discussion. It's the simple presence at a mandatory meeting by an employee. I don't see how one can get into surveillance from that type of situation. Any reaction to this morphing into a union discussion?
No, I think that makes complete sense. If anything, giving employees the ability to leave would make it easier for an employer to surveil what do employees actually think if someone goes barging out of the room, because they don't like what the employer is saying about the your point actually also brings up something else that Member Kaplan brought up in his dissent, is that the board's interference decision is too narrow, in that it only applies to mandatory meetings about unionization, but not about terms and conditions of employment. Because, of course, Section 7 of the National Labor Relations Act doesn't just give employees the right to engage in activities for or against a union, but more broadly gives them the right to engage in concerted activities regarding terms and conditions of employment, even if there's no union in the picture. So if the board's decision was actually true, the mandatory meetings, are illegal and do interfere with Section 7 rights, that would be equally true with a meeting about wages, or about pension benefits, or about how, the safety committees run. Basically, anything dealing with terms and conditions of employment as a mandatory meeting, should be illegal under the board majority's opinion, which is one reason why Member Kaplan pointed out the majority opinion doesn't make sense. The majority's rebuttal to that's relatively weak. They just said, well, this is where we're drawing the line on unionization, but not on terms and conditions of employment. If the meeting regards that, really, it doesn't make a whole lot of sense. If a mandatory meeting about unionization interferes with employees' rights, so does a mandatory meeting about any term and condition of employment.
Let's go to the final rationale. Quote, finally, because the employer has compelled employees to attend captive audience meetings on pain of discipline or discharge, the employer's message in the meeting urging rejection or support for the union is reasonably likely to take on a similarly coercive character, period. Just as employees may reasonably conclude they have no real choice but to attend the meeting, so may employees reasonably
engage in concerted activities regarding terms and conditions of employment, even if there's no union in the picture. So if the board's decision was actually true, that mandatory meetings, are illegal, they do interfere with Section 7 rights, that would be equally true with a meeting about wages, or about pension benefits, or about how the safety committees run. Basically, anything about terms and conditions of employment as a mandatory meeting, should be illegal under the board majority's opinion, which is one reason why Member Kaplan pointed out that the majority opinion doesn't make sense. The majority's rebuttal to that is relatively weak. They said, well, this is where we're drawing the line on unionization, but not on terms and conditions of employment. If the meeting regards that, really, it doesn't make a whole lot of sense. If a mandatory meeting about unionization interferes with employees' rights, so does a mandatory meeting about any term and condition of employment.
Yeah, well said. Let's go to the final prong of the majority's rationale. Quote, finally, because the employer has compelled employees to attend captive audience meetings on pain of discipline or discharge, In the meeting, urging rejection or support for the union reasonably likely to take on a similarly coercive character. Period. Just as employees may reasonably conclude they have no real choice but to attend the meeting, so may employees reasonably conclude that in fact they do not have free choice. How do you respond to that?
This inference is completely unreasonable. The notion of, having a mandatory meeting about unionization implies to employees that they would actually believe that means we have no choice on whether to oppose the union or to go for the union. It's just, speculative and baseless. It's, sort of an example of a matter of legal fiction of what an employee might believe, treating them almost like the old eggshell skull victim, if you all remember from tort law, that each of these employees would jump to that conclusion. And then, of course, if an employer in a mandatory meeting actually did create the impression that employees had no choice on unionization, I don't need to. So, for example, if the meeting, the employer says, you have no choice, you cannot unionize, that would obviously be an unfair labor practice charge. But the notion that every mandatory meeting go the act because supposedly that inference can be drawn, I think, is a real stretch.
It would appear to me to be considerable conjecture. Our last argument for the majority supporting its position here any kind of in-depth analysis. But let's go back to really the heart of this. This entire decision is based on the content that the employer is delivering to the audience. Correct? I mean, this decision, as I understand it, Bill, would not be applicable if a mandatory meeting simply discussed terms and conditions of employment regarding scheduling or vacation pay or something such as that. Would you agree with that conclusion?
Yes. By the board's own majority's decision, it only applies to mandatory meetings about unionization, or against. And that, of course, brings up the whole content-based, restriction on speech, which is, the big First Amendment flaw.
Well, let's morph into that, and that's really where I wanted to go. And then we get into a speech discussion, and the discussion then centers around what is the content of the speech, and can a governmental entity like the National Relations Board regulate content? How do you respond to that? And then I want to go further into First Amendment analysis on content.
So content-based restrictions on speech, violate the First Amendment. They're subject to strict scrutiny and are almost always unconstitutional. And the idea of a content-based restriction is if some restriction applies based upon the content of the speech. And Member Kaplan made the point, hey, this restriction on mandatory meetings applies based on the content of speech. Is it about unionization? It is. No mandatory meeting is permissible under the National Labor Relations Act, but if it's about any other subject, terms and conditions of employment or DI or anything else, it's not prohibited. So that's a content-based restriction on speech. The board majority sort of rebuttal to that is, no, because it's not viewpoint-based discrimination, because it applies whether or not the employer is for or against unionization, and therefore it's not content-based. And then they even go further than that and say, oh yeah, under the National Labor Relations Act, we only have authority to regulate speech, with respect to unions. And therefore the fact is not making other kinds of speech a function of our jurisdiction, as opposed to anything else.
So, Bill, why isn't this just conduct? Isn't the board here just relating the conduct of the employer? That is the fact that the employer is engaging in a content approach, conduct, if you will, to be more precise, is simply having a meeting that is not permissible. It's the meeting itself, not what's covered in the meeting. How do you respond to that?
They're regulating conduct, whether or not attendance at this meeting can be mandatory, not what the employer says. There's sort of two flaws in it. One, let's go 8C. 8C, among other things, says the expression of views or dissemination thereof can't be an unfair labor practice. So Member Kaplan took the position in his dissent, correctly I think, that a meeting to express a view is the dissemination of a message. The meetings are often held, by political parties and everyone else. And then turning to the First Amendment, conduct, usually restrictions on speech are sort of done under the smokescreen, as the 11th Circuit said, of regulating conduct. These are not, but the way you can tell the difference is the regulation of conduct based upon the content of the speech. And if it is, then it is a restriction on content of speech if that prohibition is only triggered based upon the content. And that would seem to be the case here. If an employer says something about unionization, suddenly the mandatory nature of the meeting is illegal. But if the employer doesn't say anything about unionization, all of a sudden the mandatory meeting is completely lawful. So it's not a regulation of conduct because the regulation of conduct turns upon the content of the speech or the subject matter.
So the minute the employer crosses the line into unionization issues and talks about that, we're in the content and we're into First Amendment restrictions. Would that be a fair conclusion?
Yes, that's Member Kaplan's position, and I think the correct one. This is a content-based restriction of speech, which we'll probably talk about the 11th Circuit decision in Honey Fund, and that's something that case supports.
Well, let's go to Honey Fund and the 11th Circuit. We've alluded to the 11th Circuit here a number of times already. Take us to the Honey Fund decision, explain what that is, and then we'll dissect it further and come back to Amazon.
The Honey Fund decision dealt with Florida's stop work bill passed by Governor DeSantis, and what the Florida law made it unlawful for an employer to require as a condition of employment that an employee attend a training or meetings that concerned certain religious or political matters, and then defined what they were. And basically it was meant to stop DEI indoctrination meetings. That was very much the intent, of that law. It went up to the 11th Circuit. The 11th Circuit said this is unconstitutional, this law, under the First Amendment, because it's a content-based restriction on speech. Because whether or not the meeting was lawful depends on the subject matter. Did it involve certain religious and other matters? And if it doesn't, the law didn't apply. And importantly, the court addressed the idea of, is this regulation of conduct versus regulation of speech? Because that was the state of Florida's primary defense. So this is just about, conduct, whether employees can be required to attend, not about the content of speech. And the 11th Circuit said what I said earlier, that if a regulation of conduct is triggered based upon the content of speech, that is a regulation of speech that triggers First Amendment scrutiny. And the court, the 11th Circuit, said that was the case of the Stop Woke Act, because it was based on the content. And the Honey Fund decision was discussed in the Amazon decision, both by Member Kaplan's dissent and the majority, going back and forth on it. But now that case is before the 11th Circuit, the Amazon case. And I think you're going to find it very difficult to get out from under the decision on that matter, given the parallels of a restriction on a mandatory meeting is triggered based upon the subject matter of that meeting. That's exactly what the board did in Amazon, and that's what happened in the Honey Fund case. And we'll see how it turns out, but Honey Fund seems to be pretty on point.
Well, let's stay with Honey Fund. So if I understand the Florida statute correctly, and then the court's analysis of the statute, the minute an employer started to deliver a message that supported a DE&I initiative or something like that, the statute was applicable and there were fines that could be imposed upon the employer. But if the employer's speech, if you will, at a mandatory meeting did not get into that type of content at all, or even may have opposed DE&I, the speech and the meeting was okay. But the content trigger, again, was if any type of speech was favorable toward a so-called DE&I initiative, at that point, the employer violated the statute. Is that a fair reading of the statute?
Yeah.
And the court said that is not conduct. Yes, you were conducting a meeting, but the minute that meeting and that conduct crossed into a censorship, if you will, of what was being said and the content of same, that's when strict scrutiny and the First Amendment principles were applicable. Fair conclusion?
Yes.
All right, so that's the 11th Circuit, and that was a decision supporting a preliminary injunction. So you had a rather high standard because we had the district court the injunction. So all four traditional prongs of injunctive relief also had to be met.
It shows how the First Amendment's a bit of a double-edged sword, when it comes to this kind of issue. I imagine you're a conservative or on the left. You may favor certain mandatory meetings on some subjects and not about others. But under the Honey Fund decision's First Amendment analysis, really any prohibition on mandatory meetings based upon the subject, is going to be found unconstitutional, at least under the 11th Circuit. Regardless of the message, of whether it's something you may support, or oppose the individual. So that's sort of interesting. I imagine many of us sitting here don't like the idea of people being forced to attend DEI struggle sessions, but the constitutional principle is the same. If restriction based upon the content of speech is unconstitutional, that cuts regardless of
15.
Well, this is not a DEI webinar, but clearly Honey Fund gets us right in the
Yellow! Listen!
Generally, as members of the public and as employees in the Amazon case, and employees also in the Honey Fund case, do come to work, and certainly we carry with us our personal viewpoints, etc. So the question then becomes, when we have a mandatory meeting, can the employer deliver a specific message?
Yellow!
And if the regulatory body in question, in this case the state of Florida, says no, if you cross a line of a certain content, that is a problem. So the governmental intrusion into delivery of speech as it relates to content. Is that where we are here, do you think?
I believe so, and I think the analysis in Honey Fund was pretty solid. But yes, is that it's sort of either the state can restrict mandatory meetings based on the content of speech, but I don't think they can under Honey Fund, or they can't. But if that's true, it doesn't matter necessarily what the content is. I mean, arguably, some could say, well, certain restrictions on content might satisfy strict scrutiny and others don't. So I guess that's a way someone could try to have their cake and eat it too. But I think that's really difficult to do. Strict scrutiny usually isn't.
To me, this is someone that regularly practices the Labor Relations Act that is becoming increasingly involved in DE&I.
Hey, Riblet!
Which is a policy situation. This intersection of
Let's get it now. Let's get it right now.
In the immediate future.
Hey, 57 color.
We'll go back to Amazon. Amazon has taken
Right side!
And your prediction is?
Hey, we're good. Hey, 15!
Especially Honey Fund, I don't see how they get around that. And that's a
Right side!
But I'd be very surprised, if the board, even if somehow this survived the appeal in 11th Circuit, that the whole idea of the mandatory meeting precedent survived, and the board to come. So this is probably something that, won't last, at least in the short term.
Yellow!
The question is, can another board...
Right side!
Is it struck down under, constitutional grounds? Because otherwise, even if the current board changes position, not current, soon to be future board changes position. All right.
Yellow!
One from 6 years from now, from doing the same.
Right side!
Puts a lid on, this ever.
Bill mentioned the board.
Fire down these two!
The National Now, there may be a legal challenge to the president's removal of Member Wilcox, albeit as of this morning, no legal challenge has been filed. And that gets us into Humphrey's
Yellow!
unitary. The NLRB, as of the moment, does not have the ability to hear a challenge to the captive audience Amazon decision and overturn it or clarify it. So I believe that in the short-term bill we will see a decision get resolved with any degree of finality. Would that analysis line up with your analysis?
Yes, yeah. It just sort of depends on, who the nominees to the board are going to be, and then when are they confirmed? To get the board back up. Member Wilcox, we'll see, or not a member now.
Hey, 88! Jump out! We don't do it!
No way.
Vacancy at the general counsel level, and that the president terminated pursuant to the former president, former LRB general counsel Jennifer Abruzzo, and then her immediate successor was Jessica Reuter, who was removed Saturday. So we have So, Bill, we might see some pullback on captive audience type complaints pending before administrative law judges and the National Relations Board for its previous system. That's certainly possible, would you agree?
Opportunity to reverse, this decision. My guess is the priority cases have gone past the ALJ, with the same allegations, because General Counsel Abruzzo seemed very much like this. So my guess is there's a future board to reverse the Amazon decision. But over time, assuming that General Counsel Cowan, isn't willing to issue complaints on this theory, the pipeline dries up. So hopefully, the board has an opportunity to voice its displeasure and return to what was the law for
We have here an attendee, quote, the board majority's position seems hypocritical. Don't union mass meetings near the workplace or unions unannounced visits to workers' houses also have the potential for surveillance and coercion? Response?
Yellow!
Absolutely. I mean, any in-person communication carries with it at least some potential for surveillance. When you talk to somebody, hopefully, you gauge how they react to what you're saying. So, any kind of in-person communication.
Oh, hell no. No way. Oh my God.
For surveillance. I think that's really stretching the meaning of surveillance. Surveillance under the act is following someone around to make them paranoid. That they're being watched, so they don't engage in protected activity. Just gauging how someone reacts isn't surveillance.
Yeah, very interesting. We have a couple of comments and updates, and thank you, Aaron Solb, and also another attendee. Gwen Wilcox filed suit this morning, I'm informed, in D.C. District Court, District of Columbia, challenging her discharge. Apparently the case caption is Wilcox v. Trump and Kaplan. So, Bill, we're going to get a test.
Oh, yeah. Which is interesting, because the test is the right word. This is very much a test case for Humphrey's executor. So it's interesting that she's pursuing this. This may very well become a vehicle for a large-scale decision on a very large constitutional matter of the president's removal.
It's going to be a very interesting Humphrey's executor decision, perhaps a Supreme Court ultimate decision. So, Bill, let's shift gears here 1 minute we've been talking about the National Relations Board, but states have gotten into this area, and as one of our attendees points out, California, Minnesota, Connecticut, and other states have passed statutes in the so-called captive audience area. Give us a little preview of where we are today.
So a dozen states have passed these laws, which are almost all written almost identically because they're coming from the same source. And basically, the laws say that an employer cannot require that an employee attend any meeting dealing with political or religious matters. And then the definition section defines political or religious matters to include, among other things, support for which I think is interesting, and we define political to include whether or not you're part of the labor union. In any case, that's how state laws are sort of written. And their main purpose actually is to suppress employer meetings about unions, not really about political matters. It's just the way they're written. So you have 12 of these laws as we're sitting here right now, and there's 4 lawsuits challenging them. The Chamber of Commerce has a lawsuit in Connecticut and more recently in California. There's a case by the Illinois Policy Institute in Illinois and a case by Minnesota ABC in Minnesota challenging these laws. And there's really 2 counts in all these cases. The first of which is the First Amendment issue, which is the one we discussed, the honey fund. And sort of the funny thing is that the board's decision in the Amazon case probably helps the preemption arguments in those cases. Because under an NLRA preemption analysis, Garmin preemption, the big question is the conduct at issue arguably protected or prohibited by the Act? By throwing the Babcock decision into question, all of a sudden the board is very clear that it is exercising jurisdiction over whether or not this kind of mandatory meetings are protected or prohibited by the Act. So in sort of an odd way, this Amazon decision helps the preemption analysis or arguments being made in those cases. All of which are district courts at various states.
So Bill, my familiarity with each of the state statutes, they all get to content in one form or another. And they involve various other content regulations or approaches, but they get to content on unionization. Is that a fair conclusion?
Define the subject matter, and then have a definition section say political and religious includes a list of things, for or against a candidate, legislation, things like that, or about a union, which is interesting that they're including unionization or the rubric of political and the definition of the statute. But it's still content-based in that if the content of speech is political or religious, all of a sudden it's illegal for an employer to hold a mandatory meeting, under these state statutes. But if it's about something else that doesn't fall under that, the meeting. Get 300! Get 300! Again, whether or not the meeting should be unconstitutional.
And you used the word bill preemption. Let's just talk about that for a moment. The former general counsel of the National Relations Board in any of these cases arguing that the state statutes were preempted. Is that your understanding?
I believe so. Yeah, I believe they have it. I think so. I'm not sure. The Connecticut case has been around for a long time. The NLRB
I have is whether the general counsel of the board or the bargaining order in any way, shape, or form intervene, arguing that the statutes were preempted. And I think I'm reasonably on safe ground saying there's no preemption argument ever advanced. Which is concerning. Again, whether you represent unions, employees, or employers, we've had a federal approach to labor relations in this country that has, for the most part, worked quite well, where we have uniformity and stability in our labor relations area. But the states into this area, as a matter of broader public policy, I think, certainly raises questions. So these state lawsuits that you just mentioned, Bill, they're in various procedural stages. We don't yet have a to my knowledge, a final decision. Is that your understanding?
Yes. The Clinton case has been around for a while. It's moving up in discovery. So I think it's getting closer to the merits now. The other three suits are relatively recent, especially the California Chamber of Commerce suit. Because it's sort of like a lot of things. One state passes it, and then the other blue states all pile on and pass the same law. So it's sort of snowball, these kind of laws.
Well, and that would appear to be the case. Of course, the Florida case that we've been talking about, a honey fund, that so-called red state, I suppose, it went the other direction, but yet the content speaks to First Amendment issues. So again, I think we'll see some very interesting First Amendment and related decisions. So we've been talking about transition at the National Labor Relations Board. We have an acting general counsel, and we have a question from one of our attendees. Let me read it. Could the new board simply concede it was wrong in the 11th Circuit and agree to have the Amazon decision set aside, or do we have to wait for another case to overrule Amazon? Bill, your reaction?
That's a good question. Would the board have to issue another decision? Because right now, boards have issued, that decision. Could a new board effectively reverse its own decision without issuing another one? That's it. Answering a question with a question. But I'm not sure in terms of board procedures if they can effectively overrule a case just by telling the general counsel, hey, don't defend it, say we were wrong, as opposed to do they have to issue a new decision? Could they, for example, say, hey, send the case back, we're going to reconsider it? Maybe. I don't know, just as a matter of internal working at the NLRB, if they could effectively overrule one of their own decisions without issuing another decision.
Well, I think, at least hypothetically, the acting general counsel of the board or a new general counsel at the direction of the board could decide not to file an opposing brief, i.e. just stay silent on the matter. I the general counsel or the board, without issuing a new decision, rolling contrary position to a issued board decision. I think that might be challenging. I'm sorry, go ahead, Bill.
Just recently came up in the next case at the 5th Circuit. That's one of the removal cases. The general counsel is saying can't take a position on the removability protections. We're good. Because President Trump, fired Member Wilcox and explicitly cited the authority
Oh my God.
notwithstanding the act's removal prohibition. So that's the position, of the administration. And the NLRB sent a letter to the court saying we could talk about other things like subject matter jurisdiction, notice of guardia, etc. But the board won't address the removability issue because the president has taken a certain position on the matter. So exactly how that all plays out, I'm not sure yet. But what position the NLRB takes on removability, is going to be interesting to see.
Yes, absolutely. I think Bill, that's that we had on agenda. Did I miss anything? Anything else
Rolling.
On your agenda?
No, that covers it. One of the things that I found in rereading the opinion for our discussion here that I found interesting was the board majority's argument under 8C. Struck me. So what the board majority said, among other things, how they get away with mandatory meetings under 8C. They said 8C only applies to unfair labor practice charges where employer motive is an element. But it doesn't apply if employer motive is irrelevant, and that includes under anything alleging that an employer statement is illegal under 881. So basically they're saying that 8C doesn't have any
Buy down these two.
to the board's suppression of employer speech. That 8C would only apply to motive and that's I've never seen anything like that. That is an incredibly, if that were true, 8C would be gutted. It would mean that at least under the act, the board would have plenary authority to censor any employer speech or union speech, that it wanted. just as a purely 8A1, 8B1A matter. So anyways, that's sort of something that sort of struck me in the opinion. I've never seen, the agency take that kind of extreme position.
Yellow!
So hopefully it doesn't survive the light of day, but that struck me.
No, I certainly think that's a valid point. And it just seems to me the broader point here is President's
Let's go. Oh my God.
Unitary executive authority to remove individuals from executive agencies like the board. And of course, there is a statute that talks about protection of board members.
Catch the ball.
Really
Thank you.
supports the removal of any board member on the theory that Amazon-like decisions have taken on major labor law policy major labor law policy implications.
43! Person!
No way.
Labor policy
No way.
Agency, if you will, not adjudication agency, and therefore the chief executive should have removal authority. It seems to me Amazon case decision would support overturning Humphrey's executor on that type of theory. And the Cemex case that many on this call are familiar with also took on very major long-range implications of labor policy in this country. So, Bill, any reaction to that as we close out?
I think that, it's right. It just shows why, executive officials have to serve, at the pleasure of the president. You have these major radical policy changes, that happen.
Let's go.
With respect to this, Cemex, there's a laundry list, of things this board did. And the notion that the president, upon taking, office has no power whatsoever to remove someone who's, engaging in an agenda which, he apparently disagrees with, sort of really gets to the idea of impeding on executive authority. And, this is one of the decisions, cited by President Trump.
Yellow!
It was joint employer and NLRB censorship of speech.
My side!
And I think that's a valid reason, as the chief executive, as sole executive authority, should have the constitutional right, prerogative, to make that decision of who's serving that kind
Yellow!
of policy.
My side!
States might be
rolling.
Challenged by member Wilcox. Be one of, quote, be careful what you wish for.
My side!
The courts, I think, increasingly are going to be
attack, get on the ball! Easy!
This case may be the lead.
My side!
Another day, and I know the Fellow Society will be tracking the whole discussion about the unitary executive theory and Humphrey's executor, so stay tuned for that. Do we have any further questions before we close out? Marco, I don't see any on my screen. Do you, Bill? Did we miss any?
My side!
We've answered all of our questions or comments.
Hey, we're good.
Bill, thank you very much. Mark, we just had a few.
My side!
Yes, Humphrey's executor. As one attendee says, the Wilcox case is the roadmap for goodbye Humphrey's executor. That may very well be true. That would certainly be my point. Thank you very much for excellent comments. Your jurisprudence in this area is well established, and we'll see if the Honey Fund case prediction that you made is a correct one. Marco, we're going to turn it back to you. Thank you to the Fellow Society for having Bill and I this afternoon.
Well, and thank you both for that fantastic discussion
Yellow.
and the benefit of your time and expertise.
15!
On behalf of the Federal Society, I'd also
My
like
side!
to thank you.
No.
On that note, we are adjourned. Thank you again.
Fuck. Patrick, No, let's go. Let's go. Dude.
Yellow, yellow! My side! Rolling, rolling.
You still get to host a discussion on the question, is DEI on its way out?
My side!
Oh no. What the
Hello, my name is Kayla Kleist, and I am an Associate Director of Practice Groups here at the Federal Society. As always, please note that all expressions of opinion are those of the experts on today's program, as the Federal Society takes no position.
Fight on these two! Fight on these two!
Now, in the interest of time and getting into the discussion, we will keep our introductions of our guests very brief. But if you'd like to know more, I highly recommend
My side!
you check out their We were fortunate to have Ken Marks, who's the founder and chairman of the
Attack! Get on the ball!
Center for Human Rights and Law, and also professorial lecturer in law at Washington University. He's also an author of 2 books, The Definition of Anti-Semitism. Before taking on his first Mr. Marcus served as Assistant U.S. Secretary of Education for Civil Rights, Staff Director at the U.S. Commission on Civil Rights, and General Deputy Assistant U.S. Secretary of Housing and Urban Development and Fair Housing and Equal Opportunity.
Yellow!
He serves by gubernatorial appointment as a member of the Board of Governors.
Oh no! 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 That's game. Wow.
If you have any questions about the program, please do submit those via the question and answer feature, likely found at the bottom of your Zoom screen, so it'll be accessible when we get to that portion of today's webinar. With that, thank you all for joining us today. Mr. Marcus, the floor is yours.
Kayla, that was terrific, especially since you're subbing at the last minute for a sick colleague. So forgive me if I make one little correction. Fun fact, I am no longer a member of the Board of Visitors of George Mason University, having been rejected by the General Assembly last week, in part, it appears, because of DEI. While most of the activity that I had at George Mason University involved questioning anti-Semitic incidents and the university's response, some of the General Assembly were concerned that I might be opposed to DEI activities that are illegal under federal law, but nevertheless perhaps undergoing at George Mason. I'm not sure that I was necessarily going to go into that, but it is a correction to the introduction that you just kindly gave. In fact, during the last few days, my own supposed opposition or support for DEI has come into the media at least once with that action by the General Assembly in their wisdom. But also I've been questioned by national reporters over the last few days on the other side of it, apparently wanting to cancel me for supporting DEI as opposed to opposing it, based significant part on my statements to the staff of OCR at the U.S. Department of Education when I was the Assistant Secretary, that I am committed to ensuring that OCR maintains an environment free from any and all forms of discrimination, bullying, harassment, and retaliation. I supported diversity, saying that essential to our mission is to ensure all employees are treated with respect and dignity. Now, major reporters at 3 national newspapers wanted to know how could anybody have served in the Trump administration who wanted employees to be treated with dignity and respect, and doesn't that mean that I must oppose the current Trump administration's opposition to DEI? So I suppose one of the questions before us is, if you oppose all forms of discrimination, harassment, and bullying, does that mean that you should support DEI or that you should oppose it? Now, interestingly, the question of DEI has been all over the newspapers, certainly for the last several days, but going back weeks and months. I have to say, when we decided for weather-related reasons not to have the event on Is DEI on the Way Out, not to have it in person at the Mayflower, one of the questions is, should we just postpone it? My own fear is that if we postponed it too long, DEI might already be gone by then, and we certainly would not want that to happen when we have such a distinguished panel ready to discuss it. I'll give you just a few quick examples just from the last few days, just from this week. Today in the New York Times, Jamel Bowie argued that diversity, equity, and inclusion is amorphous enough as a term that it can mean many different things to many different people. And I think from this panel, we'll have a sense of what it might mean or might mean to them or to us. I will tell you that when I have testified on DEI, I have found that those people who have supported DEI are talking about something completely different than those who oppose it. And we'll get a sense now of that range of thought. Yesterday, in the New York Times, PBS shutters DEI office. The day before yesterday, in the New York Times, alarmed, employers ask, what is illegal DEI? Companies navigate a legal minefield as President Trump wages war on diversity programs, but they still have to guard against complaints of bias. Sunday in the New York Times, ban on DEI language sweeps through the sciences. President Trump's executive order is altering scientific exploration across a broad swath of fields, even beyond government agencies, researchers say. Now, here's something interesting. In a column in the New York Times today, which predictably enough had some harsh criticisms of conservatives on DEI. Nevertheless, there was a concession that when President Trump announced at the start of his term that he wanted to uproot DEI from the federal government, there was some sympathy, even agreement, from those who otherwise opposed the administration in its programs. So even in the New York Times, there is the concession that DEI isn't the sacred cow, as it were, that it might have seemed to be just a year or two ago. It wasn't that many months ago that I was urged not to talk about DEI on programs, lest it be unsafe, that people might feel unsafe even to have a discussion of it. Now we can have a discussion, and I'm absolutely thrilled that for this discussion, we have 4 really fascinating thinkers on the topic of DEI. As Kayla mentioned, you can get through the website a little bit more information on all of them, but I'm going to say a few words anyhow. David Bernstein is a passionate advocate of the free expression of ideas in Israel. He's the founder of North American Values Institute, which opposes illiberal ideologies and supports liberal values in and out of the Jewish community. He's the author of Woke Anti-Semitism, How a Progressive Ideology Harms Jews. He is also a co-founder of the Institute for Liberal Values, a consortium of like-minded organizations supporting liberal principles. He is a past president and CEO of the Jewish Council for Public Affairs and a former executive director of the David Project. Nikki Neely is the president and founder of Parents Defending Education, a nonpartisan, nonprofit national organization giving parents the resources and support they need to advocate for their children's education. I'm proud to say that I am on the board of that organization. Prior to launching Parents Defending Education, Nikki created Speech First, a nationwide membership organization. She's also been president of the Franklin Center for Government and Public Integrity, a state-level investigative journalism organization. She's been executive director and senior fellow at the Independent Women's Forum, and she worked at the Cato Institute, where she created the Department of External Relations. Kim Herman serves with me here at the Civil Rights Practice Group of the Federalist Society. I guess complaints on the moderating of this event should go to Kim. So we thank her for being here. She is the executive director of Southeastern Legal Foundation. Kim advances liberty through litigation in federal and state trial and appellate courts on issues ranging from government, overreach, free speech, property rights, and economic liberty. In addition to representing clients, Kim testifies before state legislatures, drafts model legislation, and regularly publishes legal articles. As I said before, she actively is a member of our Civil Rights Practice Group, and we're delighted to have her here. Professor Yasha Monk, we're very pleased to have with us. He is a writer and academic known for his work on the crisis of democracy and defense of philosophically liberal values. Born in Germany to Polish parents, Yasha received his BA in history from Trinity College, Cambridge, and his PhD in government from Harvard University. He is a professor of the practice of international affairs at Johns Hopkins University, as well as a contributing editor at The Atlantic, a senior fellow at the Council on Foreign Relations, a Moynihan Public Fellow at City College. He's written 5 books, including his latest, The Identity Trap, A Story of Ideas and Power in Our Time. What a group. So absolutely thrilled to have the 4 of you here. I am sure that the applause would still be ongoing. Probably is. In living rooms around the world, people are applauding this great group of people. We will start with our first panelist, David Bernstein.
Great. Thank you all. I wish I could have seen you and been with you in person, but delighted we can have this conversation. Really appreciate the Federalist Society and UPenn and my fellow panelists. So I thought I'd start by talking about something that you mentioned, Ken, which is that we mean different things when we talk about DEI. I'm going to start with Exhibit A. Exhibit A, I was on a call with a very important lawyer, very prominent lawyer, about some of the problems that we've seen in K through 12 education around radicalized DEI and the like. And also about anti-Semitism that we've been seeing at the same time. And he was very troubled by the link that I drew between radicalized DEI and anti-Semitism. He was there really to talk about anti-Semitism, and he didn't understand how DEI could even be related to anti-Semitism in schools. And we started talking, and what I realized is that DEI in his law firm was simply about providing mentorship opportunities for minority law associates at his firm. That was the only program that they had, and in his mind, that's what DEI meant, the kind of program that he was doing at his own law firm. Exhibit B, I was speaking to a group of school teachers at a pretty blue school area, a pretty blue Democratic voting school district. And we were talking about the anti-Semitism that they were facing at the school, the rise of anti-Semitism. And I asked them, what's DEI like in the schools, in your school system? And they immediately got nervous, but they started to tell me about what is called white supremacy culture, or white supremacy culture framework. And it's this framework that a woman named Tima Okun put together that is quite popular. It is actively promoted by the National Education Association. And it holds that values like being prompt, or objectivity, or perfectionism are white supremacy values. And in that school system, white supremacy culture is part of their DEI program. In fact, they told me that if you even questioned it or opposed it, you could be targeted by the schools, and many of them had horror stories about raising concerns about this framework. So that's another form, that's another place on the DEI spectrum that we're talking about. And the question is, are those both DEI? And what do we mean when we talk about DEI? So I'm sure that's going to come up more. But get to the key question, though, that's been posed here. Is it on its way out? Whatever it is it on its way out? And here I'm going to say that I think there's a dual narrative at play. On the one hand, I think DEI is on its way out in the corporate sector, maybe not entirely. Maybe it will be replaced by something else, but it is certainly on its way out in many corporations. And you can talk to DEI outfits who will tell you about how much business they've lost in the last couple of years, but I'm sure even more so in the last couple of months. It is on its way out in many government sectors who are worried that they'll lose federal funding. It is on its way out in certain nonprofit organizations that receive federal funding, and I have firsthand accounts of that, of nonprofits that are scrubbing their websites of any signs of DEI because they're worried that they'll lose federal funding, and are looking for other ways of talking about or doing DEI. Some might just sort of put it on pause for a while, but I believe that's happening. On the other hand, the other narrative is that there are certain institutions where DEI runs strongest, where they're actually doubling down on it now. And they've been doubling down on it precisely because the clock is ticking. And they're worried that if they don't institutionalize this fully now, if they don't make all the recommendations that they had in their equity audit, they're going to lose the opportunity. It's easier to cancel something that hasn't gotten started. And so they want to get it fully within the system. And I think, especially in K through 12 education, where we're most active, but also in higher ed and some nonprofit organizations, you're seeing a double downing on DEI. You're seeing more radical forms of DEI. So what does that mean? What are we seeing precisely? And I'll turn to the next panelist. we talk about DEI, I think the kinds of DEI worth getting upset about, not the kind that was in that law firm, in my view, the kinds of DEI worth getting upset about are those that categorize people by identity groups, like preconceived identity categories, and insist that everybody in the system either benefits from an identity category or is penalized from an identity category. Either they're part of the oppressed or they're privileged. And they divide people up accordingly. So if it's in a school system, they'll put you in an affinity group, and the kids who are part of the white affinity group are told to take responsibility for their complicity in white supremacy, and the kids in one of the oppressed affinity groups are told to band together to oppose white supremacy. That is, I think, very common, and that I think is the basic framework of DEI that we're talking about, that I think needs to be changed. We also hear a lot about equity, and here I want to make one point, that equity is both a theory and a practice. It is a theory in the Ibram X. Kendi sense that it is an explanation for why there's disparity. Equity holds that if one group is doing better than another group on, let's say, economics or average educational achievement, that one group is riding on the coattails of white supremacy if they're not white supremacists themselves. In other words, that is the basic theory, and the practice is to make sure that everybody has equal outcomes in the here and now. And I think, obviously, that leads to some problems. One last point I want to make about DEI is I think sometimes we think of it as diversity training. It's some training program that a corporation or an organization does once a year or once every 6 months or once a quarter, and they bring some outside outfit, and they then do a ice-breaking exercise, and then everybody takes responsibility for their privilege or oppression, and then they go on and do their thing. And that happens, obviously, but I think what we're actually seeing DEI, why it's so problematic, and why I hope it is on its way out, is that it actually seeks to build the entire institutional culture around these DEI precepts. In other words, and you see this in places that have really bought into DEI, that it's how they build their institutional culture, and they measure their productivity based on disparity, based on equity, based on the status of certain groups, based on the frequency of affinity groups and the like. And I think that's what we're actually pushing back against. It's not a training program that happens once in a while. It is a program that is built into the culture of many institutions, and I think that's why it needs to be replaced. I'll stop there for now. Thank you.
Thank you, David. Nikki Neely, care to go next?
All right, let's do it. All right, well, I mean, examples of DEI abound in K-12 and higher ed. Admissions are still being gamed. The day after the Students for Fair Admissions argument, news outlets started running "When we lose, here's how we get around it" articles. Schools don't use proxies to get it raised in a roundabout way, like zip codes or lottery. Standards are dropping. We have equitable grading, which means that the lowest score you can get is the 50%, even if you do absolutely nothing, and assignments can be turned in late. Equitable math asserts that asking students to show their work and expecting them to get the right answer is harmful to minorities. And states like Oregon have suspended their essential skills proficiency requirement because standardized tests present a harmful hurdle for historically marginalized students. So, I mean, like, this is very much the soft tyranny of low expectations. Racial segregation is cool again, but this time it's through affinity groups and healing circles. I mean, like, colorblindness is so 20th century. Classroom management is now impossible because badly behaving students know that they face no consequences. In the rush to break the school to prison pipeline, suspensions and expulsions have been replaced by restorative justice, and that prioritizes reconciliation rather than actually punishing students. And in the name of inclusion, we have seen women and girls silenced. They have been forced to accept men into their private spaces like locker rooms and sacrificed awards and scholarships. This is everywhere, and this is why DEI is going to be so hard to root out. This didn't happen overnight. It was decades in the making. So while President Trump's executive orders, they order the Education Department and DOJ, it's great step in the right direction. And it has had obviously immediately positive effects. A lot of districts and corporations have said that they're dropping these programs. I think it's a little naive to think that the edifice is going to totally collapse with the stroke of a pen. I have seen a lot of parent groups and activists recently celebrating, and I feel like all I do is share that George W. Bush like mission accomplished sign meme. I hate to do that, but like that's kind of where we're at. As Winston Churchill said in 1942, this is not the end. It is not even the beginning of the end. but it is perhaps the end of the day. And I think that's a really important thing for people to realize. There is a huge amount of money at stake. I mean, forget the military-industrial complex. This is now the diversity-industrial complex, and they are not going down without a fight. A couple of years ago, my organization, Parents Defending Education, looked at K-12 consultants. We FOIA'd districts around the country, and we got hundreds of contracts looking and identifying that they were paying out tons of money for things like equity audits. I mean, is it any surprise that when you pay a consultant to come in and do that, they fail you? And the solution is to pay indulgences in perpetuity to do the work. I mean, come on. In the past few months, my organization has identified $1 billion in DEI-related grants given out over the past 4 years by the Education Department, $100 million in DOJ stop grants that were intended for school safety, yet again, hijacked for DEI-related initiatives. And last week, $261 million in DEI-related grants for school counselors and mental health professionals through mental health grants, training them on things like whiteness and privilege and microaggressions. I mean, the sums of money that are at stake are massive, but the thing that really worries me more than anything is that there are bureaucrats who wrote those RFPs. There are state and local officials who applied for these funds with terrible project ideas. Like there was one where they gave out money for the school safety grant for yoga and knitting circles. There were also federal officials who looked at the proposals, thought this is a great idea, and awarded that money, our taxpayer dollars. So guess what? As much as all the news and everybody is hysterical about all the firings in DC, there are hundreds of thousands of government employees at all levels, local, state, and federal, who share the same worldview. The rot is deep, so this is not done by a long shot. We have already, as David alluded to, started to see programs going underground. Right after President Trump signed his executive order, the ATF was caught giving its chief diversity officer a new title, and before the inauguration, DOGbackwardsss, the Department of Defense Education Agency, renamed its social emotional learning program Resilience. So this is going to continue. I mean, I think about that line from Liam Neeson in Taken. What I have is a very particular set of skills I have acquired over a very long career. If you have spent your whole life obsessing about race and gender, and you have monetized it, what are you going to do next? Like become an egg farmer? I mean, actually that you would make a lot of money, so whatever. But but really, like, what are you going to do? So I think, in my mind, for the question, is DEI on the way out? In my opinion, the answer is no. I think we're starting to see a resistance building that is absolutely going to snowball. At the moment, unions and activist organizations are the most vocal, but we're already seeing cities and school districts openly vowing to defy the president's orders. And my fear is that this is the enduring legacy of our country's failed DEI experiment. This years-long unequal adjudication of civil rights law in the country has undermined faith in the rule of law among everyday Americans. Many people now believe that the system is so broken that it is justified to ignore or even flagrantly break laws that they don't like. This is bleak, I realize that, but I don't think all hope is lost. Over the past couple years, we have had a front seat as people have started to exercise their atrophied civic engagement muscles. Speaking up at school board meetings, running for office, things like that. There is such a need for accountability at all levels of government, and people have started to meet the moment. I mean, the media is not there for it, but we are seeing people on Twitter who are transcribing these meetings. I think that's awesome. So we're very much in a see something, say something moment. DC is in its Doge era. So my call to action right now is that it's time for leaders to actually put on their big boy pants and govern. I also serve on a public university board in Virginia. I was not fired like Ken because I was put on before him. But it has been fascinating to learn what powers boards actually have versus what the administrations want you to think you have. Boards' raison d'etre is high-level oversight. It is strategy. It is fiduciary management. It is legal exposure. And guess what? DOJ coming after your university or your corporation is a significant risk. And I mean, to be clear, no entity accepting federal dollars, be it a corporation, a contractor, a university, a school board, ever should have been discriminating on the basis of race or sex before. So to the extent that President Trump's executive orders provide air cover to actually go into a meeting and demand that businesses and institutions uphold the law, amazing, great, but we never should have been doing it in the first place. This is not, as so many outlets have framed it, prioritizing needs of white men over that of historically marginalized populations. It is returning to an era of equal protection for all before the law, as enshrined under the 14th Amendment. And that used to be considered a good thing. So I welcome the storm, and I look forward to having a conversation with everybody. Thanks.
Thank you, Nikki. Kim Herman, care to go next?
Sure. I think I have a little bit more of a positive outlook on DEI being on its way out because I'm focusing on it a little bit more from the courts and what's been happening in the courtrooms. And I want to talk about that a little bit in just a minute. But I want to share with everyone just a reflection that I had as I was preparing for this and as we kind of had our Zoom calls and stuff, getting ready for what we were all going to talk about. And I was reflecting back on the first time that I addressed DEI in front of Federalist Society, which was at the Mayflower, which is where we're supposed to be today. And it was back in November of 2021. And back then, America at large was really just learning about critical race theory, right? Parents had just woken up to what was happening in our schools. The federal programs excluding Americans simply because they were white were just being exposed. We're at a very different place with respect to our understanding of DEI in this country as we are today. During that event, we talked about a number of things. We talked about programs and real life situations, like up in District 65 in Evanston, Illinois, where teachers would go into a training and they were actually being segregated by race. The white teachers are being put in one room, the non-white teachers being put in another room, and they're being taught about how to teach kids about racial issues. We talked about programs from the USDA, loan forgiveness programs, disaster relief programs, where farmers were specifically excluded just because they were white men. And afterwards, right, again, remember November 2021, I had a lot of people come up and say, are those things really happening? Or were you kind of exaggerating for effect, right? Like, is this actually happening? And here we are now, almost 4 years later, and I don't think anyone would ask that question because we know that those things were actually happening. So many worse things were happening, and they continue to happen in our federal programs and especially in a number of our states throughout this country. A lot of people refer to it as a culture war, but I'd propose that it's really better referred to as a constitutional war. And recognize that this is really important because as our government implements things like critical race theory and radical gender ideology into all of our programs and our regulations and our laws, and it's treating people differently because of the color of their skin or because of their sex, that violates the Constitution and our civil rights laws. And that's where we're actually winning, right? Because at the core, as David mentioned, these ideologies don't teach people to treat everyone equally. Instead, they're conditioning individuals, whether it be students or everyday Americans, to look at skin color, right? It's putting everyone into a hierarchy of racial privilege and then pitting racial groups against each other. With respect to sex, it's depriving women and girls of fundamental privacy rights, of their opportunities, of their voices, and it's putting them at physical danger, as Nikki mentioned. Then we've had the government using that full force and power that the government can wield to investigate these situations, to stifle criticism, and to really push this hateful ideology across our entire country. When we look at it and think about it, this is not a democratic republic, right? That's characteristics of a totalitarian tyranny, And that's really why we're at a constitutional war. And that's why so many of us, including many of the panelists here today, have been fighting in the courtrooms over the last 4 years and beyond to really reclaim our civil liberties. So with respect to racial discrimination, what has that looked like in the courtroom? Our federal courts have across the board made it very clear that our Constitution and our civil rights laws, what they already told us, that the government cannot treat people differently because of the color of their skin. They have also made it clear that using labels such as socially disadvantaged to not actually say what they're doing, but using labels like socially disadvantaged as a means to divide people by race is both inexplicable and unconstitutional. We've seen courts reject programs like the USDA loan forgiveness program that I mentioned, where white male farmers were specifically excluded. We've seen them reject 8 disaster relief programs from the USDA, which were American farmers, if they were white males, were again specifically excluded. In the courtroom, the defense that we saw from the federal government, whether USDA or a litany of other agencies that have been sued, was the same thing over and over again. They kept on arguing, well, we have to remedy past discrimination and so-called systemic racism. but they could never point to any of those programs actually discriminating. And they could never even define what systemic racism is, even assuming that that would have been acceptable to the courts, which across the board they said it's not. What they have forgotten is that our Constitution is colorblind. And I know that that's something that we talk about a lot, but we talk about it a lot because it's true and it's important. Whether or not they forgot this or they really saw it as an opportunity to intentionally write race back into our laws, you can be the judge of that, right? I don't know what their intention was. I can only suspect. But what I do know is that when we sued over these programs in court, we won. And we won because the Constitution and our civil rights laws are on our side. By one count, I saw that the Biden administration was 0 to 9 with respect to these lawsuits challenging federal programs, excluding our race admission cases. And I think that the count is actually a lot higher. That precedent's really important because assuming that we are in a constitutional war, the precedent is providing the constitutional foundation for what we now see President Trump doing in his executive orders. Okay? The executive orders are not just a campaign promise kept, but they're a clear direction that our administration is going, that they are going to abide by the Constitution and ensure that our civil rights laws are followed at every level of government. This doesn't mean that we stop fighting, as Nikki said. This is really just the beginning of the battle. It just means that we have more allies in the fight for those of us who fight in the courtroom. And race isn't the only battleground. I want to quickly mention something about sex and those other executive orders that have come out of the Trump administration, because we focus so much on race, but sex and gender is just equally as important of a battleground. And last week, I had the fortunate privilege to attend the executive order signing banning men from women's sports. And I got to take my 7-year-old daughter who plays softball to that executive order signing. Not only was it a core memory that we're still both kind of riding high from, but it was also just so unbelievably important because it also rested on the constitutional foundation of lawsuits that have been brought over the last 4 years. Right? We represented Moms for Liberty and Young America's Foundation in challenging the Biden Title IX rewrite. I know Nikki's organization was involved. There were many, many lawsuits brought, and across the board, the courts have said that that change of changing the definition of sex gender identity was unconstitutional. And that has built the foundation that these executive orders will stand on. And so lawsuits are going to have to continue to be brought. Constitutional battles can really only truly be won in the courtroom. I know not everyone agrees with that, but if we want to solidify these wins that we might be winning in DC on a political realm, lawsuits have to be brought to build that strong precedent, because that cannot be overturned in 4 years when we have a new administration. And so lawsuits have to be brought, plaintiffs have to come forward, and if we all kind of work together on that front, then I do see us bringing an end to DEI one day when we talk about it in terms of radical theories. So with that, I'll pass it back to you.
Thank you, Kim. And at this point, we are turning to Yasha Monk. Yasha?
Wonderful. Thank you very much for having me here. And it's been really interesting listening to these sets of remarks and the sort of mix of optimism and pessimism from different people who've intervened. So as the last speaker, before we go into a real discussion, I'm going to try and do my best to explain why some people are more optimistic, some people are more pessimistic. And I think it comes fundamentally from which side of the American political spectrum has power in which kind of realms of American public life. And so in general, at the moment, conservatives have more power, obviously, in the presidency and the Congress, for that can change from election to election, and in many ways in the courts, at least on the Supreme Court. And of course, liberals and progressives have a lot more power in many of the kind of traditional mainstream institutions of society, and particularly, the ones that are strongly concentrated in the cultural and the educational sphere. So not only in a lot of the mainstream media, but in institutions like the leading universities in the country and so on. And so I think that people who are closer to the realm of political power in the courts tend to believe that DI may be on the way out, and people who are closer to the cultural and the educational realm tend to be more pessimistic about the extent to which that is true. So I think that's where we can sort of derive, a first prediction about what's going to happen over the course of the next years, which is that, the Trump administration, the courts are going to push back many forms of DEI where it violates the Constitution, and that is going to lead to a significant rollback. There may be a little bit of a cultural vibe shift where some corporations and so on acquiesce to that as well. But there's also going to be both resistance and counter-reaction. There's going to be a counter-reaction because suddenly I think the pressure on university presidents and other kinds of educators from the one side is from the administration. They don't want to run afoul of the law. But on the other side is from campus, where, if you were a president or a chancellor of a big American university who wanted to reform some of the ways that have gone wrong with respect to DEI on your campus over the last few years, you might have been able to win over the majority of your faculty that probably is not that political, that's kind of center-left in orientation, that shares some of those concerns, but really doesn't want to be associated with, Donald Trump. I think now that Trump is in office, it's going to be a lot harder for those reform-minded institutional leaders to push that through, because they're immediately going to be accused of selling out to Donald Trump and selling out to the administration. And the last thing we should do is that. So actually, we should go further than that. And of course, there's going to be some realms where the power of the courts is already meeting and is going to meet, the unwillingness of many progressives to actually abide by what the law said. By the way, by what the law said in many cases before the Supreme Court's decision on affirmative action. I know from friends and colleagues, and to some extent from personal experience, that there have been many, many faculty searches at American universities over the last decades that were blatantly illegal, not just by the new legal standards, but by the old legal standards, where it was made very clear and sometimes recorded on paper that we were only looking for a certain kind of candidate, and that qualification was a racial one that clearly falls afoul of the Constitution. There's going to be some lawsuits against that, and that's going to roll back some of it. But is it actually going to succeed in rolling back all of it? I spoke to a leader of a national nonprofit organization recently, who I'm not going to identify her name, who told me, look, it's an imperative for their organization to become more diverse, and they're going to do whatever it takes to do that. And you know what? If that breaks the law, then so be it. They're willing to take that risk. And that was in the new, political and legal reality. So I think that's going to be an ongoing fight here. For me, as somebody trained in political theory, one of the questions is, can we actually get to a settlement on which most Americans can agree, on which 70-80% of Americans can actually align on what in this area do we find acceptable and what do we not find acceptable? Because a future in which for the next 30 years there's this continual tug of war where, depending on who happens to dominate which institutions at which time, we're veering wildly back and forth between different policy regimes, is not really very good for people on either side of the spectrum. So as somebody who's a philosophical liberal who believes in the basic principles of the United States Constitution, here's the suggestion that I would have. I think we should separate, as some people have mentioned, DI into various component elements. So one of those elements is, let's say it's 4 elements, right? One is a straightforward, classic, non-expansive anti-discrimination law, right? It's obviously clear that in the history of the United States, we did often exclude people on the basis of their race or their biological sex from various institutions. We need laws to make sure that, an American university can't say we don't admit people of a particular race. Fair enough. Secondly, I do think that we should be true to the idea animating the American dream, that people from all kinds of backgrounds should have opportunities. And I think that does make it morally incumbent upon many influential institutions to try and seek out really qualified candidates. If Harvard University wants to make sure that they don't just get talented students from the schools that often send people to Harvard, but also from schools that have not historically done so, sending letters encouraging people who've done very well on the SATs to say, hey, we're thinking about our institution, but your SAT scores are excellent, why do you think about applying? I think that's something that we should also embrace and so that we can have a majority in this country. I would also mention two things which I think we shouldn't do. The first of this is to create the kind of diversity trainings which are deeply rooted in an anti-liberal left-wing identitarian ideology, which defines people by their ethnic origin over other attributes they have, which defines people by other ascriptive identities over their own views and aspirations, which talks about things like white supremacy culture in inaccurate and grossly generalizing ways that humiliate students in forms like privilege walks and so on. And finally, I think we should reject ways in which go beyond encouraging candidates from diverse backgrounds to apply and making sure that we don't have arbitrary requirements for candidates, such as that they have to have a college degree in areas where that might not be necessary. Going beyond that to say, we're going to hire one person over the other, we're going to admit one person over the other at similar levels of talent, similar levels of qualification, simply because of their ascriptive identities like race and gender. That we should also reject. And I actually think that if we could get people on both sides of this fight to agree on those four principles, we could gain a permanent settlement that 80% of Americans agree with. My optimism for reaching that point is relatively low, however.
Thank you, Yasha. Thank you all. I see that our audience is already finding their way to the Q&A function, so if you have questions, please feel free to add them now. But before we start addressing any questions from the audience, let me see the participants, each of whom was fantastic, really, on behalf of the Civil Rights Practice Group and our audience. Thank you all. But I wonder if any of you would care to comment on anything that you've heard from the other panelists. Don't feel obligated, but I'll start, David, with you if you had any comment or response.
I think they all presented very well. I agree with Kimberly's take that progress in the civil rights law arena obviously bodes well for a certain kind of DEI, for ending a certain kind of DEI. And I certainly see all of what Nikki had talked about with K-12 education. I think it really is quite extreme in many circles. I think we have to, one thing I wanted to point out is that we have to understand that DEI is just one expression of this. It comes in different forms, and it's not always called DEI. It can be encapsulated in an ethnic studies program that divides people up into oppressor and oppressors, as we've seen in California and Minnesota and Washington and other places. It can be in culturally responsive education. It can be in social emotional learning. It can be it comes in various forms and in various ways. And what we're really still talking about is the same ideology, an ideology that Ralph certainly defines well in his book, The Identity Trap. And I think we have to understand that, it's very easy to change the terms here to something like belonging and understand that we might be dealing with the same thing. You have to do the deep dive. And I always urge people who are a little reluctant to take on DEI or schools or whatever, always do the deep dive and ask the questions and do what groups like Parents Defending Ed do a lot of, which is, FOIA requests to find out what's actually happening in your schools so that you know what you're dealing with. Maybe it is a softer form of DEI that you could be less concerned with. My guess is probably not. So do that work. Two years ago or so, I think it was August of 2022, my organization did a national poll. And we pulled certain terms like DEI, anti-racism, critical race theory. And at that time, critical race theory polled very poorly. It had been exposed in the public. This came after a lot of the sort of campaigns with critical race theory in the wake of the Virginia elections and the like. People had a vague idea what it was, and even among liberals, they didn't like it. What DEI, by the way, did not poll poorly, and my theory, and anti-racism did not poll poorly, because I think people didn't know what those terms meant. And they thought it was anti-racism was just being against racism, and they thought diversity, equity, inclusion was just about, diversity and inclusion, and probably didn't know what equity meant. And so I think we're going to have to be, it just shows you like there is a concerted effort in certain institutions to confuse the public. and they'll switch up terms very quickly. And I think what we have to do is train people in a way to be amateur philosophers so that they can recognize some of this ideological terminology as it emerges. The word critical, for example, I believe deeply in the critical thinking. I want my kids to be critical thinkers. And for me, that means objective analysis. In many education settings, I learned that critical thinking means critical in the sort of critical theory sense of learning to recognize and resist systems of oppression. So a teacher may talk about critical thinking and actually mean something that's the very opposite of critical thinking. So we have to help parents and other consumers out there understand this terminology and how it seeps into the discourse and how it's institutionalized if we're going to actually really turn the tide on DEI in the long term.
Thank you, David. Nikki, did you have any comments on the others?
I like Yasha's ideas. I support them, so I second the motion. And I think Kim actually made a really important point, is that the court cases have to continue, because over the next several years, we're going to have to codify the president's executive orders. There's going to be a lot of heavy lifting that has to happen. There needs to be legislating. There needs to be bills passed through Congress. As we saw with Title IX, a 37-word statute written in 1972, the Biden administration literally rewrote the definition of a single word, sex. And so I think that we're going to have to frame that out a lot more. And then also, there's going to have to be proper notice and comment. We are a nation of laws. We don't just rule with the pen and a phone. And so there's going to have to be a public comment period, but all these things will have to actually be put into practice. And that is going to be a long and slow process. And having the court wins, having the 9, 10 line victories, 4 to cite in your rulemaking as a reason why this has been struck down, in multiple appellate courts, is going to be really critical. And so there's a lot of heavy lifting to go, even in the sort of short to medium term.
Thank you, Nikki. Kim?
To that point, I would just add that if you look at the programs that we have already on the books, there's a lot more work to be done in the courts, right? I think it was Wisconsin Institute for Law and Liberty recently wrote an amicus brief in a case, and they identified that there's over 60 federal programs that use the term socially disadvantaged in the same exact way that courts have already found it to be unconstitutional. And so it's also not just going to be court cases, but it's going to be identifying these opportunities for the administration to take action, because there's, as you know, probably better than any of us can, there's an OCR process, and there's many other ways that our federal government can take action quicker and faster, even in the court system, than some private litigants potentially can. And so, I think that we're just going to see a lot of action there. But to everyone else's point, we have to continue to educate Americans on this, because a lot of us, when we do hear DEI, we think about that very first job that we had, in the 90s or early 2000s, and it really just was about mentorship programs and things like that. And so if you're not seeing this day in and day out like we do, because this is the world that we choose to live in for our careers, Americans just don't understand what's happening, and they don't know it's unconstitutional when it does happen. And so I think that we also have an obligation to continue to educate Americans as much as those in our government.
Thank you, Kim. Yasha, any other comments?
No, I thought this is an excellent set of presentations, and set of comments. Just to say one word about some of these verbal acrobatics. We have to pick our battles about which of those terms we try to explain so that people understand why they might be less appealing when they see them, and which of those terms we try to claim for ourselves. So for myself, I think that DEI is a term that we can criticize rightfully because of some of the connotations it has. I think I'm more pessimistic about being able to completely transform what it would mean, for that would have a big advantage, because certainly in more liberal leaning spaces, it's going to be a lot easier to transform what the DI office does than to abolish it. Now, I'm a little bit skeptical about whether we'll actually ever be able to truly transform it, but certainly if it'd be easier for a university president to appoint a new head of a DI center that actually is aligned with some of those constitutional principles, then it would be to abolish a DI center. So that it has some technical advantages. On a topic of anti-racism, I go the other way, which is to say that I'm a proud anti-racist. I abhor racism. My disdain for racism is an absolutely core part of my identity. I also think that people like Ibram X. Kendi and Robin DiAngelo have a crazy understanding and conceptualization of what they mean by anti-racism. And I certainly strongly object to and disagree with their ideas, but I'm certainly not willing to grant them ownership over this topic.
Thank you, Yasha. So let me ask a question, I guess, initially for David or Yasha. In her remarks, Kim argued, I think, for the vital importance of litigation to take the next steps. Since this is a legal audience, she might have had a home field advantage in arguing for litigation. Nikki, I think, agreed with that, but also pointed out some executive branch actions that could be used. And then Kim, I think, came back and also discussed the importance of executive branch administrative action. For either David or Yasha, do you care to join in that conversation from the two? Is the most important next step litigation? Is it in the executive branch? Is it something else altogether?
I guess I could start. I mean, I think litigation is key. I think litigation is a necessary but not sufficient tool to push back against this. It creates risk in the system. Executive orders, by the way, create risk in the system too. By the way, if an institution is constantly looking over its shoulder about whether or not it could lose federal funding, that can also have a huge impact. I think using trustees creates risk in the system at a university. Yasha just mentioned that he's a bit skeptical about the ability to transform DEI. Danielle Allen, who is a professor of political thought at Harvard, African-American thinker who's really wrote compellingly about this in the Washington Post, read her piece, tried to actually change DEI at Harvard prior to the Great Racial Reckoning, and it included viewpoint diversity and religious diversity as two markers of diversity. Now, if you actually included viewpoint diversity in DEI, in other words, it would be okay to have different perspectives on power, privilege, race, and the like, it wouldn't be DEI as we know it. It would transform DEI in a way that probably many of us would. Maybe we'd still critique it, I don't know, depending on that particular program. But tellingly, it did not end up being the DEI program at Harvard, as we've seen in no uncertain terms. So I worry that DEI, by its nature, is deeply embedded in bureaucracies. And those bureaucracies are people by folks with certain perspectives on the world that have gone through the DEI school themselves and are eager to teach a certain worldview, part of a certain worldview, to whoever is in the DEI program. And that's why I'm skeptical. I would be okay with the reform DEI enterprise if I thought it was doable. But I'm just worried that because of the nature of DEI, it won't be. So yes, I would use all these tools, legal, advocacy, institutional, government action, and hopefully end up in a better place.
Thank you, David. Yasha, did you care to?
Yeah, just to expand on that, I agree that litigation is absolutely key and an important tool that has already been impactful and will obviously continue to be so over the course of the next years. I also strongly agree with David that part of this is to make sure that institutional leaders have incentives on both sides. If you are the editor of a mainstream newspaper or you are the president of an Ivy League university, you feel the pressure from the progressive interest groups and the undergraduate students and the young staff as very, very strongly. I think having some pressure, whether in the form of legal threats or in the form of donors from the right to counterbalance some of those pressures, can actually sometimes enable and empower those institutional leaders to make better decisions, because if they see pressure from both sides, they actually have to go back to first principles and go back to some kind of principled way through this morass, rather than simply going wherever the loudest voices are, which is always going to be on this topic in the other direction. I would say, thirdly, that it's very important to offer a way forward that people who feel genuinely cross-pressured can take. I have a lot of empathy because my political socialization is much more on the center left, for people who are generally concerned about inequalities and injustices in this country. And I think offering them a path forward which acknowledges those concerns and makes it clear why it is that we can and we should address those historical injustices in a way that is in fact consonant with the United States Constitution and with the philosophical liberal values that it contains, is a very, very important thing. And that's a swing constituency in a lot of these institutions, right? You have a bunch of extreme activists on one side, you have a few scattered conservatives on the other side, and a lot of the middle is in that kind of mushy, if you want to be derogatory, and I probably am a mush myself, space. So you need to give them a way to get on board. Otherwise, it's going to become a more existential fight where those institutions remain captured by these ideas, and you then have to manage to reduce their role and their importance in American life, which is, I think, both going to be difficult and come with very serious drawbacks, because some of these institutions are important and valuable in other ways.
Excellent, thanks. I don't know if Kim or Nikki, you prevailed. I don't know if you want to seek fees or anything, or if you had further comments. No, okay. So, I mean, one thing I learned from the New York Times is that people on the right who oppose DEI are in favor of racial segregation and basically don't want to have any minorities hired anywhere. And yet, Nikki Neely, not known for leftism, made a comment about how institutions should not be discriminating based on impermissible grounds. So in the event that we are moving away from DEI, but for whatever reasons, we believe that institutions should not be discriminating based on race, color, national origin, sex, religion, or any other invidious characteristics, if we want to deal with discrimination, harassment, bullying, and to make sure that institutions are hiring based on merit and not based on any form of bias. David Bernstein had suggested that one possibility is that if DEI is leaving, there might be something else next. So let's suppose there is going to be something else next after DEI that might address discrimination on any of those bases or other impermissible bases. What might come next? What should come next? David, you raised the possibility that something might come next. What could it or should it look like?
There are some what I call liberal DEI practices, liberal in the classical sense. Chloe Valdery's The Theory of Enchantment, for example, is a liberal DEI practice. It's based on the teachings of Martin Luther King Jr., and she tees up special readings and discussions around equality, around more traditional concepts of equality that I think could become the basis of DEI. I mentioned when I first started talking about a lawyer who had a mentorship program that for minority associates. There are problems in certain companies and organizations that make them less friendly or inclusive to minorities. I think we can be aware of that. I remember in around 2010, 2011, I used to work in the finance district of Boston, and we'd walk around, and I would walk around, somebody else on my team, and we'd see these formations of the white guys in Brooks Brothers suits, and we could always pick out who the alpha male was in the group by how they were walking. And I thought to myself, okay, maybe if I were a minority or a woman in one of those corporations, these were probably corporate people, maybe they could use a little work. Not necessarily in discriminatory hiring practices, but to make sure that they're even aware that they might be, seeking out certain kinds of profiles and ignoring others. And also, maybe they're not providing the most inclusive environments. Maybe they're not ensuring that the CEO goes to lunch with the young black associate just as he does the young white associate. And so I think that there are kinds of DEI that are worth thinking about. And I think we still might differ on some of them, and we still might critique some of those practices. But I don't think we'd be where we are now in this national discussion if those are the forms of DEI that have been embraced and not what we see today.
Thank you, David. Anyone else?
Yeah, I mean, look, I think one of the questions is, how do we celebrate the great diversity that we now have in the United States and many other democracies around the world as well, but in a way that encourages people to connect with each other, rather than putting them in different boxes. And so I'll say a couple of things. One is that, the most successful research program in social psychology of the last, at least for 75 years, is called intergroup contact theory. And what that shows is that when people from different groups have a chance to really spend time with each other in the right kind of circumstances, they often come to have a much more positive opinion of each other and reduce a lot of prejudices. Now, there's also conditions on that. That tends to work when they are equals in the kind of situation in which they are placed, when they have a common task, and most importantly, when the authorities and the authority figures around them are encouraging them to get along, are telling them you should actually be getting along. What are examples of that? Well, the United States Army is an example of that. A sports team in a middle school or a high school is an example of that, right? You have the same goal, you have equal status as players on the team in the situation, and your coach tells you if you have any beef, cut it out. You're supposed to get along, right? Unfortunately, so much of our institutional architecture today systematically and deliberately violates those conditions, right? It is, let's come in, and the way we talk about diversity is to place you in separate affinity groups in which we tell minority groups about how ill the intentions of their fellow students or fellow, employees probably are. And we sort of shame the members of the majority group about how they are probably secretly racist and should really be careful about what's actually in their hearts. We tell people like New York University on its ID cards for students that the world is dangerous because there might be a terrorist attack and here's the number to call when that happens, and you might have a terrible medical incident and here's the medical number to call when that happens. That's understandable. Those are things you might have to worry about. And thirdly, you might suffer a microaggression and here's the bias response team that you should call when you suffer a microaggression. That primes people to expect that we're not going to be able to get along. And so I think that there's all kinds of ways in which institutions up and down, from elementary schools to corporations, should think very hard about how they can celebrate and encourage diversity in a way that actually encourages people to get into real conversation with each other, to get to know each other, to have meaningful, deep, respectful conversations with each other, rather than the opposite. And some of that is easy, some of that is hard, right? I would always choose the sports day over the affinity group. I would always choose the context in which I'm communicating, but I'm expecting you to get along, over the one where I say, you're probably going to have all of these conflicts, come to me, the authority figure, when that happens. But some of it can be genuinely misguided, but well-intentioned, right? So I spoke to a student when I spoke at a liberal arts college a number of years ago, who was a first-generation Mexican-American student, comes from a poor background. And she said to me, I was really excited when I came to college that I was going to meet people who are very different from me. But the first 2 weeks were an orientation and a training for first-generation college students, for us to network with each other and so on. And that's where I made all my friends. And now I'm hanging out with all these people who are actually a lot like the neighborhood I come from and my own family. And I understand why the college runs that kind of orientation program. I don't think that is owed to the kind of crazier ends of critical race theory or wokeness. It really is a challenge to come to some of these affluent liberal arts colleges when you come from a rather different socioeconomic background. But it's still a mistake because, of course, I made a lot of my friends in the first 2 weeks of college. A lot of people, that's when you start building social bonds and it's easy to stick with the same social group. So if that social group is precisely people from the same background, well, guess what? You're less likely to make those other kinds of connections. So institutions need to become much smarter and much more thoughtful about how they encourage the right kind of social contact and how they stop discouraging that kind of social contact, most importantly. First order of business, don't do harm.
Thank you, Yasha. Kim or Nikki, there's an audience question very similar to the one that I've just asked and that David and Yasha have addressed. If you're not woke, but also see that a certain segment of society, such as Black or Native American men, are not being educated or hired and clearly are being left behind, then how do you try to tackle that problem without discriminating?
We filed an OCR complaint against the Los Angeles Unified School District about a year ago, and they had a grant program that was a Black Student Achievement Program. There are, as I think everyone on this call realizes, many, many needy students in the Los Angeles Unified School District. But this was a $120 million grant program that was only for Black students. And I think, that is inevitably going to engender ill feelings. Schools, because of closures, et cetera. It was funny, I think, when we were during all the school closures, when parents were mad, there were some equity activists that said, well, all the schools are closed, all kids will be held back equally. That wasn't true. As we know, wealthy students were able to put their kids in private schools. They were able to do tutors. There were parents that had white-collar jobs were able to help their kids with Zoom school, whereas not all families had access to those kinds of programs. And so to the extent where we can open programs up to everyone and base it on socioeconomic need, or even the fact that multi-level classes have been scrapped because those are considered to be racist, or gifted to talent programs, same thing, where there's the wrong racial diversity mix in those. I think students do need, and they have special ones that are farther back need interventions, but it shouldn't be based on skin color alone. And that's where we're starting to see. I mean, I'm a non-lawyer on this legal call, so I'm going to get myself in trouble, but what is the mens rea? Like, what is the intent of this? Is it I only want to help the Black kids, or is it I want to help all children who have needs regardless of their skin color? And I think that is a really important dynamic that is often oversimplified in a lot of these discussions.
Thank you. Kim, did you want to weigh in?
I would just quickly add on to that if you are looking at a situation where the government has intentionally discriminated against these people, right? So you mentioned specifically, I've got the question over here, Black or Native American men that they're not being educated. Was there intentional discrimination? They were excluded from an educational opportunity, because that might violate the Civil Rights Act, right? The government can never treat people differently because of their skin color. It's a very, very high bar that government has to show what's called a compelling interest. And then the response to that has to be tailored in a very, very narrow way. And so if you're talking, at large, that this might be happening, as Nikki mentioned, in certain areas, like me in an LA school district, and it's something that you're seeing from a qualitative perspective, that's one thing. If there's actual intentional discrimination, then they may have legal recourse. We are a country of rule of laws, and so, we have to be very careful with these terms also, just like we have to be when we're talking about DEI and what is it that we're talking about. When we say discrimination, is there an actual intentional action where people are being treated differently because of the color of their skin? Or is it that the entire school, the entire area, the entire population that you're talking about here, like a school district, is underperforming? And maybe they're majority minority. And so there's very specific facts that have to be looked at. The never-ending annoying answer from lawyers is it depends. But there are legal standards with respect when we say discrimination and use these terms. And so, yeah, if there's intentional discrimination happening, then that needs to be righted. It doesn't matter who's on the other side of that intentional discrimination. The government should never be discriminating on the basis of race. It's never acceptable.
So, Kim, let me drill down a little bit on that, if I may. So let's suppose you are the head of an institution. Maybe it's a government agency, maybe it's a private institution, and you get word that one of your offices, or perhaps it's a division, seems to have an issue where African American or Native American employees are not being advanced. Maybe there's some chatter that there are good candidates who are not getting hired. You are aware of federal laws and federal liability, but you don't necessarily know when you first get that report whether it's credible, whether the candidates were the best or not the best, whether the lack of advancement is true, not true, whether it can be explained on legitimate non-discriminatory criteria. Do you then have to investigate? And if you do have to investigate, does that mean you have an office that's looking at these issues? And how does the office look at it? Does that mean that you, as a corporation or agency, need not only to defend against legal challenges, but also to be looking into whether your organization, despite your best intentions, is engaged in practices that are discriminatory? And what does that look like, and does that end up being something that others might call a DEI office, or is it something altogether different?
I think that it could look like something altogether different. I think that, we have to steer away from the idea that these are just going to be DEI offices that are constantly taking this theory and talking about race constantly, right? When I think about a DEI office in a company, I'm thinking about the trainings that we frequently see. that are brought to us by teachers or by employees, where they're being told that if they're silent on these issues, that they don't become an anti-racist educator, not in the way, that is actually against racism, but if they do not become the Ibram Kendi version of an anti-racist educator, then they are a white supremacist, right? That's what I think of as these DEI offices. But yes, our federal government, our state government, our corporations, our companies, they do have an obligation to follow the law. And so that can be done through the general counsel's office, right? It doesn't have to be an office specifically focused on diversity, equity, and inclusion. It can be attorneys that are focused on compliance with the law. I'm not an expert in advising companies how to structure their different departments, but I don't think that this needs a separate office. But yes, they do need to make sure that they're following the laws. We have them for a reason. We're not talking about giving anyone a free pass here, and we shouldn't, right? Because discrimination at any level is immoral, and it's unconstitutional and unlawful. So I just think that there's a lot of different ways that companies can do it without having a DEI office, which, as we all know now, encompasses so much more than just legal compliance.
Okay, thank you. So let me now bring in a possibly related question also from the audience. One attendee asks, I think that most would concede that there has been overreach with some of the DEI programs, but it seems to me that we should be using a scalpel instead of a dull axe. Should we be using an axe, dull or otherwise? Should we be using a scalpel? What should we leave in place if we are eliminating the sorts of programs that have been coming in for criticism? Who wants this one?
I'm happy to speak to that.
Go ahead.
Sorry, go ahead, David. I'll tee it up for you very briefly, and you can give a more substantive answer. I think it depends on the nature of what the program in a particular context is, right? As we were saying earlier, there's going to be some DI programs and departments that are more reasonable, where what they do, mostly consists in, putting on cultural programming, making sure that they're reaching out to qualified candidates for roles and, doing basic trainings on legal compliance and so on. And there's going to be other DI departments and agencies that, are in a concerted way trying to impose a very particular ideological tradition, rooted in critical race theory and the ideas of people like Rom DiAngelo and Ibram X. Kendi on the institutions, making anybody who disagrees with them feel like they're incapable of speaking out against them and perhaps even have to proactively affirm them. So in the first kind of circumstances, a much more limited intervention is probably accurate. Perhaps in some contexts, there's no need for action because they're actually doing things that are important and sensible. In other contexts, you have offices dominated by people who are so ideological, so unwilling to concede that other people are going to have other substantive views on some of these issues, and perhaps in certain cases acting in such an illegal and unconstitutional way that you need to get out the axe.
Thank you. And David, do you want to add?
I fully agree with that. Just a brief story. I was talking to a group of Jewish parents about problems with anti-Semitism in the schools, and I made my case that radical DEI is fanning the flames of this hostile environment that their kids are in. And one of the moms said, "Well, look, if I challenge my DEI program, I will lose all status in the school, and then they won't even listen to me when I complain about the anti-Semitism." And she said, "So what do you want me to do?" And from that experience came what I call, excuse the term, the batshit crazy test. And there I said, I asked the question, is this moderate DEI, or does it cross the line in what I refer to as batshit crazy? And she paused and she looked at me and she says, "It's the batshit crazy variety." And so I think we're, in many cases, particularly in schools, that's what we're up against. We're up against this highly coercive program, the way that Yaska described. And that's where I think a scalpel is just insufficient. I wish it wasn't. I mean, I think if you could perform a little surgery on these programs, and you could take the coercive stuff out, it would be worth doing. But my experience is that I think I said before that these are bureaucracies. Those bureaucracies are immune from the kind of change we're talking about. They're based on the critical race theory philosophy, and they've hired people to do DEI in that way, and that's the only form of DEI that they're interested in and willing to do. So there, I don't know how you use a scalpel. I think there you have to use the blunt tool, and then maybe build something in its place later on. But I think at least in the early stages, it's going to have to be rooting out of it.
Yeah, Ken, I'm going to go a little bit farther. I actually think I don't think it's a scalpel. I don't think it's a dull axe. I want like napalm. I want a cleansing fire. I mean, let's think back to after the Harvard hearing, right? Like Claudine Gay's first move was, "Oops, sorry, we didn't have you in our DEI program before. We'll fix it going forward," right? It's not that sorry we miscategorized Jews as oppressors when really you're oppressed. I'm Asian. I get that all the time too. Sorry, we're super inconvenient, but the whole problem is that there is an edifice built around categorizing, dividing, and doling out favors to people based on immutable characteristics, period. I think it is a completely failed experiment, and I think we just have to root it out entirely. Full stop. Foreheads on foreheads.
I think it comes
I didn't think you were going to go for the scalpel, but good, forget the gun.
I was gonna say, and I think it comes as no surprise. I agree with Nikki on that. And we're talking so much about racial discrimination, and we're forgetting about sex discrimination, right? These executive orders that are coming out, DEI, as we're talking about it, it's not just about racial issues. We also have schools, and we have people all across this country that are telling our children, right, our vulnerable children, that they should be mutilating their bodies, that they should be taking drugs that sterilize them, all under the name of DEI. And it's very easy to kind of get in the trap where we just talk about racial discrimination because we have so much law surrounding that, and that has been what historically has been DEI. But this has become such a bigger issue when you are putting our children at danger, when you are putting them in locker rooms, our girls in locker rooms with boys, when you are telling them, again, to mutilate and sterilize themselves, because that is what's actually happening. When you're taking them away from their parents because their parents won't support that, all under the name of DEI, that just goes even more to Nikki's point that we really just need to attack this full on and stop it in our country. So not only violates our laws, but it is just wrong.
Thank you, Kim. We're getting applause from the audience for the napalm comment. Others like Kim are interested in the gender question. So I don't know if anyone else wanted to speak to this question from the audience about whether the issues are different or the same when it comes to gender as opposed to race or ethnicity.
Well, let me just say this, that I think that we need to apply certainly the Constitution, but more broadly, I would say philosophically liberal principles to these questions. And that entails three things: a clear universalist standard for what our society should be like, a clear willingness to investigate whether we are falling short of those standards, and then third, a constitutional, philosophically liberal set of remedies for how to get to those standards when we are in fact falling short on them. And that is how I think about questions like how to address historical disadvantage in things like school admissions and so on, or whether to think about a topic like gender. And so, just to speak to those philosophically contentious issues around gender, I would say that from my personal philosophically liberal perspective, number one, we can recognize that there's a general question of fairness when it comes to questions like the participation of athletes who have undergone male puberty in female competitive sports. That creates an unfair form of competition, which effectively ends female sports as a fair competitive category. And so we can oppose that, for example. I think it's a question of making evidence-rooted decisions about things like hormone treatments and gender transitions for minors. And we've seen that many European countries that are not in general more socially conservative than the United States have updated the guidance in a more restrictive way based on things like the CAS review. I think where that critical evidence holds up, we should follow suit, but that is a question that is ultimately about evidence because we want to have the best interests of those people at heart. I would also go to say in the other direction that when an administration wants, as the Trump administration has announced it would do, to ban trans people from participation in the military, I would want to see strict scrutiny to make very, very sure that this is genuinely a significant problem of military readiness and therefore, a threat to a compelling state interest, because I'm deeply skeptical that it is. I don't see any reason from where I stand, from the evidence I've seen so far, for why those philosophically liberal principles should be compatible with excluding people from being able to serve our country under arms, merely because of, how they present themselves in the world. Which, by the way, last point, philosophically liberal, doesn't mean that I, as a private individual, have an obligation to refer to them as they prefer or whatever. I might be very happy to do that, but I don't think I should be allowed to be compelled to do that. But just that they want to present themselves in that way to the world should not, from where I stand, disqualify them from serving our nation in the military.
Thank you. I'd like to add to that, if it's okay, Ken. So I was in a meeting with a superintendent of a public school system, and the topic of gender came up. And the superintendent said to me, we can't be debating our kids' identities. And this was a way for him to basically say the issue of gender and gender identity is settled. In other words, we're going to keep on teaching this singular view of it, and we're not going to allow that discussion even about whether or not about gender affirming care or women's sports or what have you, because in his mind that would be debating their identity. I've heard that a lot. My organization is working on a discussion guide called Can We Talk About It? And what we do is we tee up the arguments for gender affirming care to minors and against, and biological sex as determinative, and and gender and pronouns and women's sport. We actually man arguments on both sides and sometimes multiple sides of this, and post discussion questions. Now I know that there are people who believe that simply that it's wrong, and I get it, and I probably agree with you on in a lot of cases. But what I find is that when you actually create permission structures or permission and invite the conversation, people might come to your conclusions more than they would if you just say we're going to stop this conversation from happening altogether. On the racism issue, I worked with a teacher at a school who teed up both Ibram X. Kendi's view of anti-racism and Don McWhorter, who's a black professor at Columbia, has written extensively on these topics, his critique of Ibram X. Kendi. And he said it was remarkable to watch so many of the students who had only been taught Ibram X. Kendi to actually switch sides and really get behind Don McWhorter. And I think that is a much more effective and frankly classically liberal approach to these conversations. Our kids are exposed to these debates, whether it's on Instagram or on in their schools, and I think it's incumbent upon us to allow them to have those conversations at the appropriate age level, of course.
And just to jump in very briefly, that's what I do in the classroom with questions like cultural appropriation. I'm struck by the extent to which, at this point, most of my students start from the assumption that obviously anything you might possibly describe as cultural appropriation is wrong, because that's what they've learned from their teachers, often starting in elementary school. But when you assign them some attempts to make sense of why cultural appropriation of any form is indeed problematic and we should reject it, but also texts that argue that, in fact, cultural exchange is a key part of our society, and we should celebrate our ability to be inspired by each other's cultures in a diverse place like the United States. A lot of them change their minds, and that's why it takes pedagogical work and it takes actual public debate about these issues rather than either enforcing debate about them or banning debate about them.
Thank you. So we have had just an enormous number of questions, which I think is just confirmation of the extraordinary vitality of the discussion that our panelists brought. I think there might be time for one more. It's a legal question for which I think Kim might get the right of first refusal. The question is whether we would say a word or perhaps another word about the difference between DEI and what is required by federal civil rights laws like Title VI, Title VII, or Title IX.
I don't know if I fully understand the question. By DEI as programs, let me see.
So let me
help me frame up exactly what I haven't seen the question.
Let me reframe it a little bit.
Yeah.
Some seem to think that if one is serious about enforcing civil rights laws, then one must have DEI offices, while others will say just the opposite. If one is serious about enforcing civil rights laws, then we can't have a DEI because there is an inherent tension between the requirements of anti-discrimination laws and what has become of DEI.
Yeah, okay. I think it all just comes back to semantics with that, and that kind of brings us back full circle to where we started here. Having a DEI office, not having a DEI office, we all have our personal thoughts on that, but from a legal perspective, you have to follow the law. You have to follow the Constitution. And whether or not you're administering that, again, through a general counsel's office, or whether or not you're just making sure that you follow the law, I don't know if legally it matters necessarily if you're talking about like a private company, how that happens. Now, I know there's stuff in the executive orders that we have to end all of the DEI offices, and there's different naming structures. People are going to rename things. We're already seeing it at schools all across the country. I've got parents contacting me all the time saying, hey, they've already renamed it this, even before the executive orders, right? As soon as November came and President Trump was elected, schools already started to change the language that they were using. At the end of the day, it's what you do. And are you treating people differently because of the color of their skin, or are you treating people equally? Are you violating the law, or are you not violating the law? That's what you ultimately have to look at. And segregating teachers by race, segregating students, that is unconstitutional and it is unlawful. And there's a lot of things that I think we're going to see out of this administration very early on. There's a lot of OCR complaints that they can immediately get to. I know Parents Defending Education has been very involved with filing OCR complaints over the last 4 years. We represent a teacher who the Department of Education actually found that this mandatory segregation was a violation of Title VI, and the Biden administration withdrew that finding. We've been appealing that. It's still pending. It is ripe for action out of this administration. So call your office what you may, you can't violate the Constitution. And Nikki may have something to add. I see her nodding. I don't know if you guys can see her, but I see her nodding behind the screen here.
No, and I think you hit it on the nail, or you hit the nail on the head. It's what are they doing? Are they focused on equality of opportunity or equality of outcome? I mean, when I sued the University of Michigan in 2018 over their campus free speech policies, at the time, Mark Perry at AEI did a study, and he found 92 DEI officials like pulling a salary, combined salary of $11 million. Fast forward to, I guess, whatever the New York Times came up with a few months ago. Now it's up to 208 people with, even more money. How many full ride scholarships for underprivileged, low-income students could that actually do, right? I mean, let's put our money where our mouth is. You can talk, and you can talk, and you can have all these wonderful programs on campus, but are you actually opening the door for people? You're not. And so I think, to that extent, I don't care if it's a separate office. I do care, as you said, what they're actually doing at the end of the day.
Thank you. Thank you to our fantastic panelists. Thank you to our audience who've stayed on throughout the 90 minutes. Thank you to the Federalist Society for hosting this event of the Civil Rights Practice Group. And thank you, Kayla, for subbing for Marco Lloyd and doing an excellent job of putting it all together. Kayla?
Well, I'll echo those thanks to our panel. We really appreciate you all joining us this afternoon and sharing your valuable expertise and insight, even in a virtual format. Thanks also to our audience for joining and participating. Welcome listener feedback by email at fedsocforums@fedsoc.org. And as always, keep an eye on our website and your emails for announcements about other upcoming virtual events. With that, thank you all for joining us today. We are adjourned.